Good morning. Can we please have your full name? And do you have any objections to taking the prescribed oath?
I don't have any objections.
Yes, then let's have your full name, please.
Madimpe Tabo Josiah Makhashwa.
I think if you can spell it, it would be of great use and help. Just spell it, please, the surname.
My surname is Mogashoa.
Yes. I take it you have no objections to taking the prescribed oath?
No objections, Chair.
Well, do you swear that the evidence you will give will be the truth, the whole truth and nothing but the truth? Please raise your right hand and say, "So help me God."
So help me God.
Thank you. Witness sworn in.
Thank you, Chairperson. Thank you to the members of the tribunal. Thank you to council. I'm indebted to everyone with regards to the time given this morning with regards to further consultations with Mr. Makhashwa. In leading the evidence of Mr. Makhashwa, Chairperson, I will be relying on Volume 11A, Volume 8, and Volume 19. So it's Volume 11A, Volume 8, and Volume 19. Thank you, Chairperson. Mr. Makhashwa, is it correct that you're an attorney and you're a director of Diale Makhashwa Incorporated Attorneys?
That's correct.
How many years have you been practicing as an attorney?
I was admitted in 2000 and I've been practicing since.
The practice of Diale Makhashwa Incorporated Attorneys, how long have you been running that practice?
We established the firm in November of 2011.
What are your qualifications?
I've got a B.Proc degree.
In the year 2020, you were requested to submit an affidavit. I want you to look at the volume 11A, pages 1 to 21, and confirm whether that is the affidavit that you have submitted.
Which pages?
Volume 11, pages 1 to 21.
Okay.
Volume 11A.
It looks like it, yes.
Okay. And did you testify at the Zondo Commission?
Yes, I did, Chair.
Were you provided with a transcript of your testimony that you provided at the Zondo Commission?
I believe Mr. Paver made available a copy to me.
Okay. On page 4 of your affidavit, which is on page, which is the one I referred to from page 1 to 21, you provide a purpose for this affidavit.
Yes, Chair.
Is it correct that the affidavit was provided for the purposes of responding to some of the allegations that Ms. Martha Ngoye and Mr. Fani Dingiswayo had made at the Zondo Commission?
Yes, I was asked to compile an affidavit and to go testify there as well.
And is it correct that your affidavit deals with all the events that took place with regards to you handling the CIA matters right until the, and your interaction with the chairperson, Judge Makhubele?
Correct, Chair. Those were the issues I was asked to speak on.
Now, before we start dealing with the events, as you've set them out in the in your affidavit, kindly just indicate to this tribunal who instructed you to deal with who instructed you from PRASA to represent PRASA in regards to the CIA matters?
I received a call in 2015 sometime from Mr. Fani Dingiswayo.
Sir, can you raise your voice a bit?
Okay. Or must I sit closer to the mic? Is it better? All right. I received a call from Mr. Dingiswayo in 2015 sometime. And he said to me that he had 3 instructions which he wanted our firm to defend. And in that way, we got instructed on the matters with case numbers that were in 2015. And I think subsequent to that, later on, we received additional 2 new instructions in respect of the matters with case numbers that end with 2016. So it was Mr. Dingizwayo.
I'm going to refer you to your affidavit on page 7, paragraph 12.1, 12.2, and 12.3. Do you see that? That is volume 11, your affidavit on page 7, paragraph 12.1, 12.2, and 12.3.
Yes, I do.
Now, in regards, you've set out the matters that you were requested to defend on behalf of PRASA, is that correct?
Correct.
Just for the purposes for the tribunal purposes, can you read out the different case numbers that were provided you in regards to the different years that you were given in?
All right, I think maybe to make things easy, I would start by reading out paragraph 12 itself. And it says that I imagine that for purposes of this submission, it is not necessary to differentiate between the various companies under this group, given that they may have been controlled and owned by the same person or people. In this context also, it might work out easier to only mention the various case numbers of each of the action proceedings instead of tabling out fully the nature of the matters they were given, that the available affidavits and other documents in this matter set out those specific details. Column 12.1 says, on or about the 23rd of September 2015, our firm was instructed by PRASA to defend in respect of the summons by the CIA group under case number 74281 of 2015. I think secondly, we say on or about the 25th of September 2015, our firm received 3 more summonses by the CIA group against PRASA under case number 73933, 73934, 77333, all of 2015. And we go on to say that on or about the 29th of June 2016, our firm was instructed by PRASA to defend it in respect of 2 summonses issued by the CIA group with case numbers 47597 and 47598 of 2016.
So in total, there were 6 matters.
It would seem so, yes, Chair.
Did you accordingly defend these matters?
We went on to file the relevant appearances to defend in respect of all of them.
Did you file any pleas?
I think at some point we would have had to. Yes, we did.
Okay. Can you take us through as to, after you received these matters and you filed your relevant pleas, what then happened?
So I must start with the time after the pleas had been filed.
Well, just if you can give this tribunal an
Yes.
indication as to what did you then do after you had filed your notices of appearances to defend all these matters. What then happened with these matters?
After filing appearance, okay. Thanks, Chair. So we were given instructions to defend these matters. I think especially with the matters with case numbers of 2015, after filing our notices of appearance to defend in respect of, it's either 3 or 4 matters that year, we received, I'm sure my affidavit says that we received applications for summary judgment in respect of some or all of them. And I think we went through the various stages of dealing with the summary judgments. My instructions were to oppose the summary judgments at the time. And I think we had an opportunity to argue 1 or 2 or more of these matters, with the result that the summary judgment applications were refused. And I think, if I'm not mistaken, this may have happened before we received the instructions in 2016, as in the 2 additional cases that my affidavit refers to. I'm not quite sure whether we went on. It's possible that we went on to raise an exception or two in some of these matters. And if my recollection serves me well, we went on to argue an exception, and the court did not quite rule in Prasa's favor. And I think that may have triggered that we then go on to file pleas, which I want to accept that we went on to do.
After the pleas were filed, what process did you and the counsel for Siaya matters agree on?
There may have been issues about jurisdiction raised in some of the matters. And I think we agreed with the other side that we must have gone on to file such of the pleas in the main pleas as special pleas, I believe. And I think the attitude towards both parties was that the matters then be referred for arbitration, to the extent that in some of the agreements there might have been some allegations that arbitration was one of the preferred ways by the parties to have disputed matters adjudicated upon. So I think there must have been some arrangement to then move the matters onto the arbitration forum.
Was a date for the arbitration set?
There may have been a date or two set, yes. I will have to be taken through what I said previously about the exact details of what happened with the arbitrations. But yes, I remember the March or February 2018 arbitration date, and I remember the September 2017 date of arbitration.
Can I refer you to your affidavit, paragraph 16? On page 8.
Yes, Chair, I'm on it.
On line 1, 2, 3. On the third line, there's a date that was provided there.
I see that the affidavit says that the parties managed to agree to the appointment of a retired Judge Fritz Brandt as an arbitrator, and all the remaining 5 matters were then scheduled to be heard between the 11th and the 22nd of September 2017, yes.
Thank you. Now, Mr. Mahasha, prior to the 11th of September 2017, there was a 417-418 inquiry. Are you aware of the same?
I recall that, yes, Chair.
Were you part, did you have any role to play in regards to that inquiry?
I think after receiving the subpoenas, we were contacted by PRASA that instructed us to assist it as an entity with managing whatever assistance or requirements by the PRASA officials that had been subpoenaed to attend the hearings. So we were instructed to attend the hearings, as may have been scheduled then.
The evidence is that the inquiries took place on the 28th and to the 31st of August 2017. Were you present at the inquiry?
Yes, personally, I think I went there on 1 or 2 occasions, correct.
And when you went to these inquiries, who was testifying at that time?
I think we as a law firm representing PRASA would have taken part in proceedings that involved those of the PRASA employees that were subpoenaed to attend the sessions. I can't quite remember all of their names, but I'm sure there is a record that refers to that.
The record of the inquiry has been, evidence has been laid in regards to the record of the inquiry. 6 people are said to have testified at the inquiry. Were you present when Mr. Baltek testified?
I may have been present, yes, Chair.
Were you present when Mr. Vermeulen testified?
I remember Mr. Vermeulen's name. I may have been present when he testified.
Were you present when Mr. Kobue testified?
I remember Mr. Kobua. I may have been present when he testified.
Were you present when Dr. Mtimkulu testified?
I believe at the time he was not an employee of PRASA, so we did not participate in proceedings in respect of persons who were subpoenaed but were not in the employ of PRASA at the time.
Mr. Bopape, were you present?
I don't know Mr. Papape now.
And Mr. Lucky Montana, were you present?
I met him, but I was not part of the proceedings that involved him.
What was your instructions with regards to your role at the inquiry?
I think the instructions may have been to be on a watching brief for PRASA, to observe the proceedings, and to the extent necessary, report on whatever feedback there was to give PRASA regarding the proceedings themselves.
During the inquiry, which was held over a few days between August and in August 2017, I want you to inform this tribunal in regards to the instructions that you have been provided with. What role did you actually play at this inquiry?
Even as far as the 417 and 418 scheduled dates were concerned.
Yes.
I think we were, in simple terms, just present when our witnesses that were in the employ of PRASA were concerned, were testifying. I understand the nature of 417, 418 proceedings to not be of such a nature that we, even if we are on a watching brief representing clients, employees, I don't get a sense that the proceedings are of such a nature that we would interact or interfere with the work of the commissioner directing the proceedings at the time. If there is one submission or two we made, if at all, it may have been at the end of the sessions that had involved PRASA's employees, when through counsel for PRASA at the time, appointed counsel for PRASA, Advocate Tsetsawane SC, I remember him making submissions when he was asked if there was anything for PRASA to add. I remember him making submissions that PRASA would appreciate receiving a copy of a report or the report of the commissioner. And one understood that that may have been limited to only the information that the PRASA employees gave testimony around.
Did you ever receive the commissioner's report?
I have not been placed in possession of the commissioner's report. I've not seen any report by the commissioner up to now.
To date?
To date, yes.
The actual transcript of the proceedings, the inquiry, have you ever been placed in possession of the actual transcript of the inquiry?
I've never been placed in possession of the actual transcripts of the inquiry either.
Which of the companies of, if you can recall, which of the companies of CIA had been placed in liquidation?
I can't quite recall. I will have to go through my affidavit if it refers to it, Chair. But yes, I do recall that it became known sometime after we had started defending the matters that one or two of the CIA companies had either applied voluntarily for liquidation and that the liquidation proceedings were underway.
Now, excuse me, who was representing the liquidators at this inquiry?
So, Chair, I think when we first entered appearances to defend the various matters, I recall that it was Matopo attorneys. My opponent colleague was Tsepo Matopo. And I believe that even after one or more of the companies had become placed under liquidation, his firm continued to play a role. Although there may have been another set of attorneys representing the liquidators after the company was placed in liquidation. I can't at this stage make firm confirmation about the details of the other law firm.
And who was the evidence leader at the inquiry?
I remember Mr. Bottas, Advocate Bottas, SC, running the proceedings mostly at the time.
At this stage, when this inquiry was being held, are you able to inform the tribunal whether or not Mr. Bottas was representing any of the companies, the CIA companies?
I was under the impression, Chair, that I know for a fact that he was counsel for the CIA group of companies, even long before we had come to know that at least one of them was in liquidation. And I think he continued to act as counsel for the CIA group and all the liquidators.
Now, Mr. Mokhashwa,
Mokhashwa, if I may
Mokhashwa,
yes.
Mr. Mokhashwa, the proceedings, the inquiry proceedings took place in August. You've indicated to this tribunal that the arbitration was set for the 11th and the 12th of September 2017. After the inquiry, did the arbitration proceedings take place on the 11th and the 22nd of September, as had it been agreed upon?
You mean as had been scheduled, I guess?
As been scheduled, agreed upon.
I don't believe that we proceeded. There may have been some discussions around a postponement, and it could be that we were approached by the legal team for the liquidators or CIA that perhaps there be a postponement of the scheduled proceedings of between the 11th and the 22nd, I think that's what we say, of September 2017. And possibly my affidavit deals with it, Chair.
I wanted to refer you to volume 19, page 76.
I'm on page 76, Chair.
Yes. This is an email from Mr. Buertes, which is addressed to yourself. It is dated the 6th of September 2017 at 10:26, so it was 10 past 10, and it was addressed to yourself and CC Ms. Ncebekazi Mpembe and certain other officials, including Mr. Tsepo Matopo. Now, do you remember this email?
I can't say I quite remember it, but I mean, if it was sent to me or to us, then it was sent to us. But I can't quite remember. These things happened, I think, some time ago. I can't quite remember if it's easy to verify. And if this is the email, then I accept that this is it.
Okay. After this whole, excuse me. After this inquiry, you cannot remember as to whether or not, you indicate as that you cannot remember as to whether or not the arbitration did in fact take place on the 11th of September 2017. Is that what you've indicated?
The arbitration did not take place.
What happened to the matter?
For which
If
period
it did not
must I
take
speak
place,
of?
what then happened to the arbitration matter?
I suspect that there may have been some advances from the other side that the matters be postponed. And I went on, I must have gone on to obtain relevant instructions from client. And then that may have led to an agreement that the arbitration proceedings be postponed.
Mr. Mahashwa, please can you inform the tribunal whether or not you were ever requested to make reports in regards to as to what had transpired at the 417 and 418 inquiry?
Yes, I'm not sure if it was as a result of a request, but there are summaries I went on to provide to PRASA, summing up what we had understood at the time were further requirements by the Commission in as far as the employees of PRASA were concerned. And if those summaries are not contained in my own affidavit, I may have referred to them as attachments in Ms. Ngoye's own affidavit. And I can't quite make out whether I had attached those summaries to my own affidavit. At the time, I was requested to come up with one for purposes of the State Capture Commission. But there were summaries the firm prepared.
But for Mr. Buertes being the evidence leader at this inquiry, I just want to understand this. Was there anyone else who led the evidence or cross-examined the witnesses who were testifying at the inquiry, especially at the time when you were at the actual inquiry?
I think in the 2 days that I was there, it's only Mr. Buertes who was leading the witnesses. or interrogating them as maybe.
After the actual 417 inquiry, and having heard, or let me first put it this way, did you hear the concessions that were made by the employees of PRASA?
I got to understand from the proceedings prior to coming here that there were concessions made. And I think in my interaction with the then chairperson of the PRASA board at the time, part of what was raised with me was that PRASA employees may have considered to some of the issues that had to do with the claims by the CIA group of companies.
Sorry, can we just deal with the question? As I understand it so far, you were there on at least 2 days, and during those 2 days, it was when the PRASA employees testified at the inquiry. Is that correct?
Correct, Chair.
Now, the question that's asked of you, were you then present when the PRASA employees made certain concessions, and in particular, did they admit that money was owed by PRASA to CIA, as far as you can recall?
I don't have that recollection, Chair. And if I may just add, if it will help, I would wish to be referred to the summaries that I prepared for PRASA after the proceedings, if they are part of any of the bundles here.
I just want to get the answer clear.
I don't recall there having been any concessions, Chair.
While you were
And it's
there.
it might be a tricky question for me because what amounts to concessions? I'm not sure. We went on to ask that the report, or at least parts of the report that involved or had involved our witnesses, be made available to us. I don't have any transcripts of what transpired. I do not have any, or I have not come across any report that speaks on at least the summary of the testimony of the PRASA employees at the time of the 417, 418 proceedings. And I'm neither in a position to make remarks or take a view that they did not concede. As far as my recollection is concerned about my having been in attendance at that particular point in time, I don't recall there being any concessions, or particularly concessions that would have had an impact on the matters we were defending.
Thank you, Chair. Mr. Makhashwa, after the inquiry, did you in fact make reports that were submitted to PRASA with regards to what had taken place at the inquiry?
Yes, I remember preparing very brief reports, and I think the reports may have concerned themselves about what I understood were further requirements by the Commission in as far as the PRASA witnesses were concerned. And I think part of what was expected of the PRASA witnesses, or PRASA itself, was that PRASA engages further with the representatives of the CIA group of companies in order perhaps to compare notes on some of the issues that may have been considered to be outstanding, which the parties needed to compare notes on. And I think my reports would would have dealt with that.
I'm sorry to interrupt again. Do I understand your understanding of what flowed from the PRASA employees having testified at the inquiry was that there will be a further engagement with CIA's representatives? Is that it?
I remember that my reports dealt with that particular specific requirement by the Commission that there be further engagements between PRASA and the CIA group of companies, or representatives of the CIA group of companies. I remember that because I have had to sit down and jot something down for clients in as far as the inquiries were concerned. That is why I have a recollection of the contents of my own reports to PRASA at the time.
Mr. Makhashwa, is this before Judge Makhubele became the chairperson of PRASA, these reports you're talking about?
I'm not sure when Judge Makhubele joined PRASA, but it was soon after the 417, 418 hearings themselves. So if you say that they happened towards the end of August, it must have been somewhere in the early September that I prepared those reports for PRASA.
Just one more question. Who were you dealing with at PRASA at that stage?
At that stage, it would have been primarily Ms. Shumi Mukotedi, and I think from time to time, I may have been dealing with Mr. Dingizwayo in as far as whatever instructions that we sought may have been concerned.
So it was Mr. Dingizwayo at PRASA who was giving you instructions?
It was both Ms. Mukotedi and Mr. Fani Dingizwayo.
Yes. Thank you.
Thank you.
Thank you. Mr. Makhashwa, after this inquiry, it is not in dispute that Judge Makhubele was then appointed as the chairperson of PRASA, and that this was in October 2017. Did you have an opportunity to meet with Judge Makhubele at the time of her appointment, which is in October 2017?
I think the first time we met in person was when I got invited to attend a meeting at PRASA. And I think that must have been around the 4th of December 2017. But because I had had prior engagements with Judge Makhubele long before her coming to PRASA, after getting to understand that she was going to be the chairperson of PRASA, I gave her a call and congratulated her.
Chairperson, if you can please assist, the room is becoming a little too warm. I'm not sure whether we could just turn down the temperature a little bit, or may I have leave to take off my jacket?
You certainly have leave to take off.
Thank you.
I think we must sort out the temperature in the room because it is getting quite warm.
Thank you.
Stand down for 5 minutes to see if we can sort it out.
Please, Chairperson, I really am warm, but I was going to take off and continue with the evidence.
Well, let's sort this out.
Thank you. Thank you.
Ready to proceed?
Thank you, Chairperson. I'm indebted. Now, Mr. Mukasho, I want to indicate to you that at this tribunal, we have got two reports that you prepared. One of them is dated the 21st of November 2017, and one of them is dated the 30th of November 2017. But let us start with the one dated 21 November 2017, which you will find in volume 8, and it is on page 233.
I'm on the page, Chair.
Thank you, Chair. That report, as already indicated, it's dated 21 November 2017. It is addressed to Fani Dingiswayo and Ms. Shumi Mokotedi, and it is subject report on progress on Siyaya files. The case numbers are depicted as 73934 of 2015, 73933 of 2015, 74281 of 2015, 77333 of 2015, 47597 of 2016, 57598 of 2016. And you indicate with regards to the arbitration date, postponed sine die, arbitrator retired Judge Brandt. Do you see that?
I see that, Chair. Yes.
Okay. Have you had an opportunity to go through this report?
Yes, we drafted it many years ago, and I think I would be familiar with all of the submissions that are contained in this report.
How did it come about that you had this report drafted?
I was asked or requested by the legal department of PRASA to prepare a report on the status of the SEA group of matters. In as far as us being attorneys who represented PRASA in the litigation thereabout.
And from whom did you receive the request?
It must have been from Mr. Fani Dingiswayo and Ms. Shumi Mokotedi, because I see it is addressed to them.
This report that you compiled, does it detail the matters?
Yes, the report would speak a bit about the nature of each one of the matters, the amounts claimed, the basis upon which these claims are founded. I think the report would speak a bit about the progress in litigation that had been made up to that point when the report was formulated. The report possibly gives a brief snippet on what PRASA thought were the applicable defenses for each and every one of the cases.
After this report, you then submitted a further report, which is the one dated 30th of November 2017. And your reports, that report is also in volume 8, and it is on page 266.
I'm on the page, Chair.
How did it come about that you compiled that report?
All right, I think sometime after submitting the report of the 21st, I got contacted by Mr. Dingizwayo, who had at the time forwarded an email in which he had attached, if my memory serves me well, a memorandum by the chairperson of the board at the time. And his instructions to me were that I must deal with those aspects of the chairperson's report that had to do with our firm. As in, I must give information regarding what our firm's position is in as far as the aspects of the chairperson's memorandum that had to do with the firm itself.
When you say that he attached the chairperson's report, I wanted, which would have been a memorandum. I wanted to refer to page 248 in volume 8.
Yes, I'm on page 248, Chair.
Do you recognize that memorandum? It is by the chairperson. It's to Acting Group Chief Executive Officer, Mr. Zide, from Chairperson Interim Board Advocate TAN Makhubele SC. It is dated the 28th of November 2017, and the subject is CIA Consulting Engineers in liquidation inquiry in terms of section 4171 and 4182 of the Companies Act 61 of 1973. Is this the report, chairperson's report, you say was forwarded to you?
All right, I see that the opening introduction in our report of the 30th of November, which is on page 266. And I think I'm trying to answer your question, but I think I must first refer to the report. It says that we refer to the above matters, and in particular to our report of the 21st, subsequent to which we have now been placed in possession of a report which is prepared by the interim board chairperson, Advocate Makhubele SC, addressed to the acting CEO, Mr. Zide, which report is dated the 30th of November 2017. Now we go on to say that given that the report was made available to us yesterday, the 29th, we can only accept that the date that appears on the chairperson's report was noted in error, as the report could only have been dated the 29th or some date prior to that. I see the report is dated the 28th of November 2017, the one you refer me to on page 248. So I can't say if it is the same report that was in front of me when I was dealing with the request to make further submissions in the report of the 30th of November 2017.
Okay. Let us deal with the issues that are raised in this internal memo dated 28th of November 2017, so as to determine whether or not your report dated the 30th of November 2017 would in fact be in response to this internal memo dated the 28th of November 2017. Okay.
Okay.
Chair, if you can just give me a moment. Right. Paragraph 2 of the memo 28 November 2017, it states, I confirm receipt of a report from process attorney Diala Mukhashwa, dated 21 November 2017. It appears from the contents of the report that Diala Mukhashwa attorneys were appointed to defend 5 civil actions that were instituted by CIRDP Consulting Engineers, PTY Ltd, and CIRL Solutions Pty at the Gauteng Division High Court, Pretoria. The former, which instituted 4 of the actions, subsequently went into liquidation. I'd like to refer you now to paragraph on page 267. Paragraph, it's in the middle of the page, it's written 1.6. We now deal with the chairperson's report as discussed in paragraphs here below. Paragraph 2, it is noted the litigation and CIA's subsequent voluntary liquidation. Do you see that?
Yes, I do, Chair.
I would like you to take a moment to quickly peruse that, the sub-bulletins there below, and indicate to this tribunal whether you address the issue as per the request in the internal memo dated 28 November 2017.
You want me to read?
You don't have to read it into the record. We're providing you with a moment to go through the paragraphs and determine whether you are responding to what has been requested of you in paragraph 2 of the internal memo dated 28 November 2017.
Thank you, Chair. Yes, Chair, I've considered the contents of paragraph 2 of the memo.
Are you responding to paragraph 2 of the internal memo dated 28 November 2017?
It seems that, yes, I'm giving a brief overview of that introductory statement as contained in the chairperson's report.
Let's go on to paragraph number 3 of the memo 28 November 2017. It is not clear from the report of Mukhashwa Diale attorneys whether they were subsequently appointed to represent PRASA to deal with the liquidation matter. As acting group CEO, such instructions would have come from you. Further on in paragraph 4, it also appears from the report that at some point the matters were referred to arbitration, but what is not clear is whether this happened before CIA Consulting Engineers went into liquidation or not. Reading your paragraph, reading your response in paragraph 2 on page 267, do you respond to paragraphs 3 and 4 of the internal memo dated 28 November 2017?
Yes, I think my report was simply meant to clarify what I had thought were issues raised in paragraph 3 and 4.
Okay. At this point, before we proceed on to paragraph number 5 of the internal memo, are you in agreement that your correspondence dated 30 November 2017 is in fact in response to paragraph 2, 3, and 4 of the internal memo dated 28 November 2017?
And I'm going to assume that the report that was in front of me is similar to the report that I'm being referred to on page 248. And if that is the case, yes, it would seem that I was trying to give more information about the matters and their history and where the litigation of the matters was at the time.
Do you then confirm that the report of 30 November 2018 was response to that memo dated 28 November 2017?
Yes, as I say, if the report is the same to the one I had received on the 29th, my report of the 30th would have been intended to assist PRASA further in as far as we were requested to, given the interim chairperson's report at the time.
Thank you, Mr. Makhubele. Then, in regards to the report of 30 November 2017, I want you to turn to page 268 of that report. This is still volume 8, page 268.
I'm on the page, Chair.
On paragraph 3, you then deal with the 417 and 418 proceedings in terms of the Companies Act. Is that correct?
Yes, that's what appears on the report.
And on that, you give a detailed report on these proceedings, right until paragraph 3.12.
Yes, Chair, that is so.
At paragraph 3.11, you indicate, which is on page 270, you reiterated the issue of, to date, our office has not been placed in possession of any or all of the documents that may have been made available to the chairperson of the interim board. To this end, it is not certain to us under what context, it is not certain to us under which context the chairperson concludes that these assertions may not be entirely correct. Did you make that assertion?
Yes, we included that in our report, paragraph 311, Chair.
Okay. Now, in the report of 28 November 2017, it had been clearly indicated by the chairperson that she was in possession of these documents. Did you indicate, or between the 21st of November and the 30th of November, or at the time when you are compiling your report on the 30th of November, did you request for this information, this document, in regards to what the chairperson had? Did you request this from Mr. Dingiswayo?
As in, did I request that I be placed in possession of which copies?
The documents that the chairperson was referring to in her correspondence dated the 28th of November 2017.
Which paragraph, I may ask, of the chairperson's report?
I think, if I may, just take the witness again through what it is you're trying to deal with. Ms. Nguni.
Okay. What I'm trying to deal with, Mr. Makhubele, is the fact that you responded to the contents of the correspondence by the chairperson, which were addressed to Mr. Zide, the interim report dated 28 November 2017. You responded to this this memo in your memorandum dated the 30th of November 2017.
That's correct.
And in this memorandum, because you indicate that in your memo, sorry, Chairperson, let me just try and rephrase this question. In paragraph 5 of that memorandum from the chairperson, in paragraph 5, it is stated, you are aware that the attorneys acting for CIA Consulting Engineer in liquidation approached on about 14 November 2017, and they provided me with a copy of an interim report of the inquiry in terms of the Companies Act that was prepared by the Commissioner and dated 15 September 2017. They also attached copies of email communication between Mr. Madimpe Mukhashwa of Mukhashwa Diale and Advocate Francois Boetes SC. The email communication is also attached in Mukhashwa Diale attorney's report. To this paragraph, you then accordingly responded with regards to that in your correspondence. Am I correct?
I would want to believe that the report of the 30th, yes, it would have dealt with what the chairperson's report refers to under paragraph 5, to the extent that the report says that I may have been in communication with Advocate Boetes regarding the matters we were defending, alternatively regarding. Well, yes, as contained in the report or the interim report of the chairperson or the report of the interim chairperson at the time, it would seem that there was a report, at least in the possession of the chairperson at the time.
And after submission of your report on the 30th of November 2017, did you ever request the assistance of maybe Mr. Dingaswayo to getting hold of this report for it to be submitted to yourself for you to peruse?
I think, as my own report says, of the 30th of November, at that time I had not seen the report. Previously, our firm may have made attempts to get a copy of the report from our opponents. Subsequent to this report, I made the point to the chairperson that I have not seen the report, at least in our meeting of the 4th of December. But around this time of the report, of this report, I may have mentioned to Mr. Dingizwayo and Madam Mukotedi that I have not seen. No one had placed the report in our possession.
Okay. After this report was provided to Mr. Dingiswayo, what then took place?
Which report?
The
My
30th
report of the 30th.
Your report after your submission of the 30th of November 2017, there were further engagements that took place. What engagements were those? And with whom?
I think if my memory serves me well, I may have received a call from, I can't remember whether it was Mr. Dingizwayo or Mr. Zide, that I'm invited to present myself at the PRASA offices on the 4th or thereabout of December, to meet with the PRASA officials about the CIA matters, or the CIA group of matters. So I was invited into a meeting at PRASA.
I'm going to refer you to your affidavit on page 20. Sorry. I'm going to refer you to your affidavit on page 12.
Which volume?
Volume
Chair?
11A, your affidavit. Page 12, paragraph 24.
Not volume 19, volume 11, you said?
11A.
Okay. Page 12.
Page 12,
Thank you, Chair. I'm on it.
paragraph 24.
Yes, Chair. Must I read it?
No, you don't have, can you just indicate what it says? You don't have to read the paragraph into the code. What does it say?
Well, it says that on or about the 4th of December, I received a call from Mr. Zide with instructions that PRASA wanted me to come to their offices for a meeting with the chairperson, Ms. Makhubele, regarding matters our firm was dealing with on behalf of PRASA against the CIA group of companies. Ms.
Okay.
Mbebe and I then decided to prepare the reports we had been asked to prepare previously, and we took them with to PRASA, I suppose. And I see that I was asked the same day that I was expected to be at the meeting.
Okay. Did you attend the meeting?
Yes, Ms. Mbebe and I attended the meeting.
Who was at this meeting?
Well, according to my affidavit, which is correct, the meeting was hosted by Ms. Makhubele and Mr. Zide. So to answer your question, it was myself, it was Ms. Mbebe, it was Ms. Makhubele and Mr. Zide.
Sorry, let's just have the names of the people present at the meeting on the 4th of December, 2017.
Okay, other than myself, Chair, it will be Ms. Mbebe, who was my candidate attorney at the time. And when we got to PRASA offices, we were received by then chairperson, Ms. Makhubele, and I think Mr. Zide, who I believe was the acting group CEO of PRASA.
Just the four of you.
It was just the four of us.
At the time when you arrived at the meeting venue, and it was yourself, Ms. Mbebe, Ms. Judge Makhubele, and Mr. Zide.
Yes, correct, Chair.
Take into consideration that you had already been informed, as you say in paragraph 24, that it was in regards to the CIA matters. Did you inquire into the whereabouts of Mr. Dingiswayo and Ms. Mokotedi?
Well, I was told at the meeting that that is the meeting with the officials that were there at the time.
Okay, take us through what was discussed at that meeting.
And I think my affidavit is going to help me in that recollection. And I think it is important to note that Ms. Mbebe and I took with the reports of the 21st and the 30th of November because we thought that the reason for the meeting would have been about those two reports which we had recently prepared. Ms. Makhubele indicated that I had actually come into possession of a document that was internal and private to the entity itself, and that it was not supposed to have been passed on to me for any reason.
Please, can you assist us, Mr. Mukhashwa? What documents are you referring to that Judge Makhubele, you say Judge Makhubele says you should not have been in possession of that document. What document are you talking about?
All right, I'm talking about the document we were going through just now, which is on, is it page 248, the internal memorandum by the interim chairperson. I believe you said it's 248, I can't quite remember. In volume 8, that's the memorandum. You would recall that I've tried to indicate that to the extent that the memorandum of the 30th of November refers to the fact that because we received the memo on the 29th, we could only conclude that the copy we had erroneously pointed out the date 30, because when it was given to us, it wasn't the 30th yet. So to the extent that the two reports are similar, but for the dates confusion, this is the report that Ms. Makhubele was referring to. Because she mentioned that it's clearly addressed to the acting group CEO. It was not addressed to DLM Khashwa.
What else did she indicate? Is there anything else that she indicated?
I think she then made the point that perhaps so the instructions that I come up with the second report of the 30th were not instructions that ought to have been directed at me, in as far as dealing with the contents of the internal report by the interim chairperson may have been concerned. And that otherwise, to the extent that we had been acting for PRASA in the CIA matters, PRASA will take a view on whether there are any instructions for the firm to still continue with the matters or not. And if so, what those instructions would be. I think that's the note at which the meeting ended.
I want to refer you to paragraph 25 of your affidavit, Mr. Mukhash,
Oh, yes?
to the line starting with extent that it originally. Can you see that line? Paragraph 25, page 12.
Originally.
Paragraph 25.
I'm looking at it.
It is the
Chair.
fourth line from the bottom of that paragraph.
The third line starts with the fact that what she had addressed in an internal document to Mr. Zide was then distributed and shared. Is that the line you're talking about, Chair?
No, I said from the bottom of the paragraph, that paragraph 25. If you then go to line 1, 2, 3, 4, 5, 6, 7.
I think I'm at a loss.
Paragraph number 25, line number 7.
The sentence that starts
In
with
the
she
middle
pointed.
Yes, can you read what is stated there?
She pointed out that she was not going to accept our report of 30 November 2017 that responded to the memo in as far as our firm was concerned, given that her memo was not meant to us in the first place.
Was there anything requested with regards to the memo, the memo dated the 28th of November 2017, which was not supposed to be in your possession? Was there any request made by Judge Makhubele with regards to what you need, how you needed to deal with that memo?
Are you referring to an internal memo?
Yes.
Well, it was presented to me that that memo was not intended for me or for our firm altogether. When I think, as she correctly points out, the memo was addressed to the interim acting or the acting group CEO at the time. We were simply, instructed by legal to give regard to the memo and assist with submissions to the extent that our firm was referred to in the memo itself. And I think that is what the report of the 30th had been formulated to achieve.
Can you refer same paragraph, page 12, same paragraph 25, I want to refer you to line number 4, towards the end of line number 4.
Are you on paragraph 26,
Paragraph 25,
line number 4?
line number 4.
We are
towards
at
the
that
end.
point.
Yes. Can you read that out?
We were at that point requested by Ms. Makhubele to hand over her memo back to her, but given that we had received it electronically, we undertook to discard with it to the extent that it originally was not meant for our firm.
What's your response to that request?
That we would discard with the memo accordingly.
And after the meeting, did you in fact discard the memo?
Yes, we must have.
Okay. What else was discussed at this meeting?
I'm going to look at paragraph 26 of my affidavit. It would seem in the first sentence of paragraph 26 that Ms. Makhubele pointed out to us that she was in possession of an insolvency inquiry interim report dated the 17th of September 2017, which was directed to the Master of the High Court. I see that I go on to say to her that our firm had not been placed in possession with the report she was referring to, and that this was so despite that we may have reached out to our opponents to do so. I go on to say that she voiced out concerns that she was not sure how PRASA was going to deal with the report at the arbitration proceedings, which at that time had been postponed to March the following year, 2018, given the evidence of PRASA's employees at the insolvency inquiry.
And at the end of the meeting, what was then indicated to you and Ms. Mbembe by Judge Makhubele?
I see that at some point I made the point to her that it was going to be difficult or impossible for me to comment on her concerns raised without the benefit of the contents of the report she was referring to. In closing, we were advised by Ms. Makhubele that Mr. Zide would in due course inform us in writing how PRASA wishes to proceed with the disputed matters and how PRASA was going to deal with the issue of the memo that had been sent to our firm inadvertently. The meeting then closed on the same day. I telephoned Ms. Ngoye and Mr. Gizwayo and Ms. Mukotedi about the meeting with Ms. Makhubele, and in particular, I referred to the fact that she had expressed displeasure at the fact that our firm had been placed in possession of an internal memo of PRASA.
Mr. Mokhosha, is it correct that on the 15th of December 2017, there was a further meeting which you were called to at PRASA?
To my recollection, yes, Chair.
Did you attend the meeting?
I was in attendance, yes.
Who was in attendance at this meeting?
I think if my memory serves me well, it was myself, Mr. Zide, and Ms. Makhubele.
What was discussed at this meeting? From your recollection, Mr. Mokhasha, what was discussed at this meeting?
What I remember was discussed is that Ms. Makhubele indicated to me that PRASA had considered its options about the litigation and had come to conclude that it might be in the best interest of the entity to settle some of the disputed matters. And I was taken through the cases which it was thought be settled. And I was taken through each and every one of those cases. And I think some amounts were referred to that were meant to be amounts that PRASA had intended to tender to the other side. And that it was not going to be in the interest of PRASA that the matters be defended any longer than what was the case at the time.
Sorry, can you just assist us here? There was a meeting on the 15th of December 2017.
Correct, Chair.
Present at that meeting were just the three of you.
It was just the three of us.
You, Mr. Zide, and Judge Makhubele.
Correct.
The purpose of that meeting, as I understand it, is that you were going to, or that you were given instructions to settle some of the cases that CIA was involved in. Is that correct?
Yes, I was informed that I had been invited into the meeting so that they share with me what PRASA has resolved to do about some of the matters.
Now, just on that point, the advice to settle, whatever it may have been, did not come from you.
I did not advise PRASA to settle if we are talking about the settlements that ensued thereafter.
Yes.
It was not because of my advice.
Who then was it that raised the issue that PRASA must settle with CIA? If you didn't raise it, who raised it for the first time?
Can I just take you back to the meeting of the 4th?
Yes.
The chairperson shared with me that she was in possession of a report by the liquidators dated the 17th of September 2017. I made the point that I was not in possession of the report. She otherwise expressed concerns, what she raised as concerns, about some of the evidence that was led by the officials of PRASA. And I imagine at the time it may have been officials who testified when they were still in the employ of PRASA, or some of the former officials of PRASA. I think the fact is I had not seen the report, so I can't quite make out what the extent of the submissions therein contained were. And I think I made the...
Just stop there for a minute. This was when?
On the 4th, the first meeting with the PRASA officials, including the chairperson and Mr. Zide.
And this was referring back to the evidence at the 417 inquiry. Am I correct?
That is the report she was referring to at the time.
And she indicated that she wasn't happy with some of the evidence given by the PRASA employees. Is that correct?
Correct.
Did she indicate to you or to those present at the meeting what part of the evidence caused the unhappiness on her side?
Not in so much detail to me, Chair, because, and I did say to her, it would be better to have me respond in circumstances where I have the report itself in front of me. But to summarize it, yes, she said she was concerned about some of the submissions, perhaps by the witnesses from PRASA, that it was thought compromised some or all of the PRASA's defenses in as far as the litigation of the matters was concerned.
Can we just stop there for a minute? You were present when these witnesses testified at the 417 inquiry.
Correct. I attended some of the hearings. Correct, Chair.
You wrote, as I again understand it, 2 memoranda as a result of that inquiry.
I wrote about 4 reports. Correct.
Yes, well, 4 reports.
Correct, Chair.
And in both those reports, you don't mention the fact that these witnesses referred to by Judge Makhubele at the meeting of the 4th of December had made admissions or had given evidence to the effect that PRASA may well be liable to CIA.
I did not deal with the nature of the evidence of the PRASA employees at the hearings, not in the reports that I presented to PRASA soon thereafter.
Your recollection of the events then, of what happened at the 417 inquiry, do you agree or disagree that these witnesses had made certain concessions that PRASA ought to pay CIA?
I think to be fair to your question, Chair, I can only say that I'm not in a position to say I agree or not. In truth and in fact, during the proceeding itself, I may not have been paying attention. I think I was in attendance with, so our team comprised of a senior counsel and a junior too. If there was anything for there to be said on behalf of PRASA, it would have been my counsel team. So why I prepared the reports that I did at the end of the proceedings is because of the interactions at the time as we were wrapping up. Those reports do not have anything to do with the quality or lack thereof of the evidence that the PRASA officials had led. And this is precisely why it had always been important for me to get the transcript, because then one would have been able to apply some attention to what the witnesses actually said. So I'm not in a position to respond to whether, in my view, out of what I had heard, the witnesses were saying things that were against the grain of the defenses that we were instructed to present.
And was that still your view on the 4th of December at this meeting?
I don't understand the Chair's question.
You said you were uncertain as to whether these witnesses made concessions to the effect that PRASA must pay CIA. Would that be correct?
Well, so when I wasn't sure if they had made the concessions at the time of the meeting with the interim chair.
And that was your position on the 4th of December?
That was my position on the 4th of December, and I think this is why my affidavit would go on to say that I made the point to her and Mr. Zide that I'll probably be better placed if I were to gain possession of the documents so that I comment if my comments were required.
Then can I ask this, just on this issue, were you ever supplied with the document which indicated to you that PRASA had made these, or PRASA employees had made the necessary concession for PRASA to pay CIA?
To this date, I have never seen the interim report as at that time, I believe. I'm not sure if there exists the final report, and I had not seen the transcripts either, if they were ever made available to anyone.
Thank you.
Thank you, Chair.
Okay. Thank you, Chair. Let us go back to the meeting of the 15th of December 2017. Okay. At that meeting, you indicated that the settlement, the issue of the settlement of these matters was then discussed.
Yes, that's correct.
And it was also indicated that it would not be in the interest of PRASA that the matters be defended.
That is correct, Chair.
Okay. Now, you further indicated that you were given amounts with regards to what was to be settled on. Is that what you indicated? And you said you've got it in your affidavit.
That's correct, Chair.
Now, I want to refer you to paragraph 31. On page 15 of your affidavit.
I'm on it, Chair.
Okay. The amounts depicted at paragraph 31.1, 31.2, 31.3, 31.4, who gave you those amounts?
All right. The last sentence of paragraph 31 of my affidavit says, it was PRASA's wish, as expressed by Ms. Makhubele at the meeting, that the remaining 4 matters be settled, and that in that regard, PRASA had worked out that the offers be made as here below outlined. And that will be from 31.1 to 31.4.
Yes, but who actually gave the amounts?
Ms. Makhubele did.
Did she give the amounts and the case numbers as reflected?
Indeed, the amounts would have been in relation to the various cases that we were defending with their unique case numbers.
Did you note these down?
I must have scribbled them down at the time, yes.
Right.
I'm sorry, just to interrupt again. As I read paragraph 31 of your affidavit, please correct me if I'm wrong. It appears you were receiving instructions to settle these claims as per the amounts reflected in paragraphs 31.1 onwards. Is that correct?
Correct, but it was more like the chairperson at the time expressing a view that it is PRASA's intention to settle in line with the amounts as stated in paragraphs 31.1 up to and including paragraph 31.4.
This had not been discussed with you by anyone and at any forum or fora previously that PRASA must settle.
Not up until at that point of the meeting of the 15th of December.
That was the first time you heard of it.
That was the first time PRASA had expressed wishes to have the matter settled. And according to my notes, in line with what I state in paragraph 31.
Thank you.
What else did she indicate in regards to those amounts and the settlements in regards to those cases?
I see that my affidavit further makes the point that the PRASA wished that there be confidentiality provisions regarding the intended settlement offers, and that the offers be made without admission of liability, and that they will be for settlement purposes purely. I see that I say that I made the point at the end that if indeed it is PRASA's position to have matters dealt with in the manner that was expressed in the meeting, that our firm as a service provider and creature of instructions would oblige and act accordingly if such instructions were presented to us in writing. I say that the meeting ended on that note.
Okay. Were the written instructions provided?
Paragraph 33 of my affidavit states that there was a letter sent through to me from Mr. Zide's office, and that the letter contained in it offers that our firm was instructed to make to the other side.
Just as a point of clarity, after the meeting of the 15th of December, while you waited for the written instructions, which you now refer to having come from from PRASA through Ms. Matsemela, did you engage with Mr. Dingiswayo or any person from the legal team with regards to the settlements that you had now received instructions on?
You mean around the 15th or on the 15th?
On the
Chair?
15th of December, after the meeting with Judge Makhubele and Mr. Zide, it was indicated that, you've indicated that you requested that it be written instructions. After that meeting, were there any discussions by yourself with any member of the legal department with regards to the discussions that had taken place on the 15th with regards to the settlements?
All right, I can't quite recall when it was, but I suspect that after the meeting, because members of the legal department were aware that I had gone through to PRASA's offices for the meeting with the group CEO and the chairperson. I must have received a call from Mr. Dingiswayo, who asked me what the meeting was about and for details like that. Now, I think what I have not come out to also say here is that one of the things that were discussed at the meeting of the 15th was that I was to accept that the PRASA, the CIA matters, or the CIA group of companies matters, or the litigation matters in respect of this group of companies, was now going to be the responsibility of the board, and that it was now PRASA's board that was going to take responsibility for the further conduct of the matters. And that it then would not have been PRASA's requirement that I interact with the legal department in as far as the further conduct of these matters was concerned.
Sorry, can you repeat the last part? Therefore, not PRASA's requirements that?
It wasn't then PRASA's requirement that I further be in contact, or beyond that point be in contact with the PRASA legal team regarding the further conduct of the CIA matters, because they were now going to be the responsibility of the board, and that any communication to my office would have been through the office of the CEO or acting CEO.
I'm sorry, I don't quite fully understand your answer. I think the question was, were you ever told not to discuss what happened at that meeting with anyone? Yes or no?
Well, Chair, I think I was addressing a different issue with the evidence leader, but to answer your question, I was instructed not to take instructions from legal on the CIA group of matters anymore.
Well, I understand that, but were you ever told not to discuss these matters with anyone from the legal department? And if so, who did tell you that?
I'm not sure, Chair, if I must draw a distinction between whether the instruction was that I stopped dealing with legal or whether the instruction was that I stopped talking with the legal department. I was given instructions that in as far as these matters are concerned, the further conduct would be from the office of the acting CEO, and that it was not necessary for me to any longer be in contact with the legal department in as far as the further conduct of these matters was concerned. Now, to me, or for me, it meant that I was not supposed to then have discussions about what was happening with the matters, with the members of the legal team.
You say that was your understanding of what was said to you at that meeting.
Correct, Chair.
By whom? Who said it?
Oh yes, I was given the instructions by the interim chairperson of the board, Judge Makhubele.
And did you convey that to Mr. Dingiswayo at any stage?
Yes, Chair. I think this is where I was still trying to deal with Ms. Zungu's question, whether I had had discussions with anyone at PRASA about the meeting of the 15th. Now, I can't recall whether I called him or he called me, but we spoke on the 15th, and when he inquired about what the meeting was about, I said to him that I was instructed that I must now only deal with the office of the acting CEO in as far as the further conduct of the CIA matters was concerned, and that the matters were now in the hands of the board of PRASA at the time. That was the response I gave him.
Well, what did you think of it? You started out with these matters having received instructions from the legal department of PRASA. Is that quite correct?
That's correct.
And then come the meeting of the 15th of December, and they simply cut out. Is that correct?
It's not unusual, Chair, to get such instructions from
Now,
entities.
it might not be unusual.
I was concerned and worried about it, if that answers your question. And that's as far as I can take it. I was concerned and worried about it. And it was an issue for me to deal with going forward. And I handled it in a manner that I did. I shared with Mr. Dingiswayo what my instructions were. In fact, I indicated to Mr. Zide after the meeting that given the position I was in, he must give members of his legal department feedback on what I am instructed to do about the matters going forward. I didn't want to be placed in an uncomfortable situation where I must explain myself about things I'm not responsible or was not responsible for at the time. So I had pleaded with Mr. Zide to give the legal department that feedback about what I was instructed further on about the further conduct of the case. So yes, it was a point of some discomfort, but as I say, I carried out the instructions our firm was instructed to carry out.
You then indicate that you waited for the the written instructions. So when you left PRASA that day, where did you go to?
Probably home or the office.
Okay. Now, the next question
yes,
is...
yes. Sorry about that, Chair. I think it was the 15th, so the meeting may have taken place in the morning because I got notified about it the day before. I was assured that written instructions will follow.
Yes.
So during the course of that day, I ended up receiving the written instructions. And I think this is the point that my paragraph 35 says, that the lady in the office of the acting CEO transmitted a letter of instruction that bore Mr. Zide's signature.
I'm going to refer you to volume 8, page 272.
Page 207.
272.
I'm on it, Chair.
Do you recognize this correspondence?
Yes, this looks like a letter of instructions I went on to receive on the 15th.
Was it in line with the notes that you had taken?
I think to a large degree, yes. Because I would have had to attend to that comparison. I don't recall calling PRASA for them to clarify any position, which means I understood the letter of instructions very well in the context of the meeting we had had. In any event, my requirement that instructions be made in writing was to enable me to then have record of what exactly PRASA wanted the firm to do in as far as the intended settlement was concerned.
In regards to paragraph C on page 273 of that instruction, interest payable, do you see that?
I see that.
Was that discussed at the meeting, in the meeting during that morning? Was there any discussion in regards to interest?
If I may, Chair, I saw that part of my affidavit deals with that we may have been, or it may have been expressed that it was PRASA's intention to also include interest in the settlements. I'm not sure if I'm right to say this, but I may have seen it somewhere. Otherwise, outright, I can't recall if we discussed or debated the issue of interest in that meeting.
Sorry, Chair. Thank you. After receiving these instructions from Mr. Zide dated the 15th of December 2017, what did you proceed to do?
I think our firm went on to prepare offers in line with the instructions given, and the offers were accordingly communicated to the legal representatives of CIA or the liquidators. I think it was somewhat of a same-day exercise.
Sorry, you say they were communicated to whom?
To Mr. Matopo's office.
What took place thereafter?
Possibly the 15th was on, I can't remember whether it was on a Friday or not, but soon after that, I received communication from Mr. Matopo's office that went on to raise issues about the fact that my offers did not include or incorporate in them the interest that may be payable as a result of these offers.
Can I refer you to a correspondence dated on 18th December 2017, page 276 of volume 8?
Yes, I'm on it, Chair.
Is that the correspondence that you received from Mr. Matopo?
This is the correspondence that I received from Mr. Matopo, yes.
I want to refer you to page 277, paragraph number 2. What does it state there?
It says your settlement offers do not comply with the provisions of Rule 34(5)(c) of the Uniform Court Rules. You received instructions from your client, PRASA, to submit the following settlement offer or tender to our clients. And then I suppose it repeats the amounts as may be contained in the offers that I had made.
What else, what is contained other the cases that are dealt with them? What else is said there?
So the letter refers to the case numbers and the amounts. And then it goes on to say, plus interest, a tempora mori at 9% per annum on the aforesaid amounts, calculated from the date of the service of the respective summonses until final date of payment.
Paragraph 3.
Your client, PRASA, did not instruct you to submit an offer or tender to our clients in respect of the capital amounts only. Your client's specific and express instruction to you was to submit an offer or tender to our clients, which provides for the payment of interest at the rate of 9% calculated from the date or dates upon which the respective summonses were served on your clients.
And what did you make of these two paragraphs, paragraphs 2 and 3? What did you make of what was said in that correspondence to yourselves?
Well, I was a bit confused because I would have asked myself how my opponents would then raise issues about instructions I had been given.
And how did you then, and did you raise these concerns with anyone at PRASA?
Not particularly, because I think when I went back to consider the letter of instructions, I had picked up that indeed there was an issue of interest that I had to have levied on the amounts of the tenders made. I may have made a remark to PRASA that when I went on to seek instructions on adding interest to the figures, I may have gone on to make the point to PRASA that it's a bit strange, but I think that's where I left it.
Okay, Mr. Mukhashwa, did you do anything about these particular paragraphs with anyone at PRASA, or did you not?
About the issue of interest?
No, about the issue of what the instructions were to you. Remember, you are saying in the correspondence, Matopo attorneys are saying to you, your your client Prasa did not instruct you to submit an offer or tender to our clients in respect of the capital amounts only. Now, the question is, you indicated that you were concerned in regards to how did they know what your instructions were. My question is, did you do anything about that? Did you query with Prasa whether they had, did you query with Prasa this correspondence of what had been contained in this paragraph? Did you query this with anyone at Prasa?
No, I think because I considered this to be some position that Prasa was asked to look at, I probably forwarded this letter to Prasa and asked that they confirm whether I should go on to factor in the interest, because their letter of instructions indeed does say that interest must be factored in. And I think about these 2 points, I didn't take this issue beyond some remark to Prasa that, well, I don't know why they're saying what they're saying. In as far as the issue of interest is concerned.
This correspondence, did you forward this to Prasa?
Yes, I must have done so.
At this stage, Chairperson, I'd like us to take the lunch adjournment.
Yes, certainly. We will then adjourn at 2 o'clock. Therefore, stand down until 2 o'clock today.
Sure.
Yes. We may continue. If I may remind the witness, you're still under oath. Off you go.
Thank you, Chairperson. Mr. Mukhashwa, we were still on the correspondence dated the 18th of December 27, which is on page 276 of volume 8, you remember?
Correct, Chair.
You were asked as to, did you send the letter dated 18 December 2017 to anyone at PRASA? What was your response?
I said to you, I must have done so, yes.
And do you remember to whom at PRASA did you send it to?
I was communicating with Mr. Zide, the office of the acting CEO, at the time.
Was there a response to this when you forwarded this correspondence of 18 December? Was there any response from Mr. Zide?
Yes, there was a response that had then given me instructions to present calculations that factor in the interest.
Okay, I want to refer you now to volume 11A, where your affidavit is contained. Volume 11A, where your affidavit is contained. I'm going to refer you to page 31.
Paginated 31.
Paginated 31.
I'm on it, Chair.
This is an email from Mr. Zide dated Thursday, December 21, 2017 at 9:45 to Mr. Madimpe Mukhashwa, subject arbitration for CIA / PRASA. Dear Mr. Mukhashwa, I've read the above subject matter and it will be in order for you to proceed as per the proposal. Many thanks and regards, Al Zide.
Yes, I see this, Chair.
Was that the response you received?
I think this response was in response to my having presented revised figures that include interest.
Okay, then I'm going to refer you to page 281 of volume 8. Excuse me.
Yes, I'm on the page, Chair.
The documents noted at page 281 is noted as in the private arbitration between CIA Rail Solutions and Passenger Rail Agency of South Africa, case number 47597 of 2016. And then in that, it's headed as the settlement offer. Do you see that?
I see this, Chair.
Okay. Now, if you turn over, you will go on to page 282 and 283, and further it says settlement offer. There are 3 case numbers that are given on that document on page 283 with amounts that are reflected thereon. Do you see that?
Yes, I do.
Are these the documents you're saying you sent to Mr. Zide?
I can't remember if I sent him the actual settlement proposals or what communication I sent him that must have told him that between the first offers made and now, here is the interest. Would it be your instructions that I now revise the figures to include the interest? In the alternative, I may very well have sent these to him to look at and approve.
Okay. Let me try and assist you, Mr. Mukhashwa. If you look at the letter dated, 18th December versus the instructions dated the 15th of December, which is on page 272.
Yes, I see that.
You see that? You will note that the amount, if you look at paragraph 2 of the letter dated 15th December now, on page 273, you note that
Yes.
2.2, 2.3, 2.4, 2.5. If you look at that, the amounts there are the same as contained in paragraph 2 of the letter dated 18th December 2017.
It seems so to me also, yes.
Okay. Then if you now go to page 281.
I'm on it, Chair.
The amount in regards to that case number, which is 47597 of 2016, the amount on that settlement offer is 22,693,575 rands. Do you see that? This
Yes,
is
I
now
do.
in regards to case number 47597 of 2016.
I see that.
Okay. If you go to the letter of the 18th of December, which was the one saying to you that these are not your instructions as you have not filtered in the interest, and you look at paragraph 2, under that paragraph 2.4, it refers to case number 47597 of 2016. The amount is now 19,583,778. 42. Do you see that?
Yes, I do.
Okay. Let us go on. If you look at page 283, that settlement offer, and you start with the first settlement offer, which is number 1, case number 47598 of 2016. If you look at the letter dated 18 December 2017, number 2.1, the amount is 15,371,739 of 87. You see that?
I do.
And now in the settlement offer, the amount is 178,70,174 and 3 cents. You see that?
Yes, I do.
So do you then confirm that the amount as reflected in paragraph 2.1 to 2.4 of the letter dated 18 December 2017 have now been amended on that settlement agreement as reflected on page 281 and 283?
Yes, it is indeed so. It appears to me that pages 281 and 283 of, I think it's your bundle 8, which pages contain offers that are dated 21st of December 2017. These would indeed be offers as revised after having added on the applicable interest at the time.
Thank you. And did you then send these revised offers to Mr. Matopo?
Yes, after receiving instructions from clients, I went on to do so.
Okay. And these revised offers would be in line with what Mr. Zide is saying in the email on page 31 of volume 11A, in that email.
That I must proceed.
With
Correct.
the proposal, okay. Right. Did you send these settlements to Mr. Matopo?
I must have sent them to Mr. Matopo.
Was there a response?
I think I'm looking at your page 286, a response by Francois Botes on the 21st of December 2017. And in this response, it appears that he had been instructed to accept the revised offers.
And that was on the 21st of December 2017 at 11:21.
Correct, Chair.
Now, I have further emails in your volume, which is in your, as part of your bundles, which is on volume 11A. I want you to turn to page 32. of volume 11A.
I suspect I'm on it, yes, 11A, I'm on page 32.
Okay, that email that you see on page 32 is the same email as reflected on page 286 of volume 8.
Yes, the one we just went through now.
Okay. Now, this is the email whereby counsel, Advocate Boertes, is accepting the process settlement offers as reflected on page, as reflected on the pages that we've just read, which was page 281 and 283.
I agree with that.
Okay. And further in that email of Mr. Boertes, he indicates our client's instructions are furthermore to request your client to expedite the payment of the amount concerned and that it be attended to on an urgent basis. Was this email of Mr. Boertes brought to the attention of Mr. Zide?
I think naturally I would have gone on to report the developments to clients, yes.
Okay. You then, did you respond to this email of Mr. Boertes?
I may have to acknowledge receipt of their communication.
Can you please turn over to page 33 of the next page of that same volume, right? If you look at the bottom, it says on 31 December 2017 at 11:57 a.m., Madimpe Mukhashwa, you then wrote, "Good morning, sirs. We acknowledge receipt of your correspondence here below and have taken note of the contents thereof. Kindly note that we advised our client of your acceptance of the offers tendered as well as your request that payment be effected on an urgent basis. We will soon revert regarding client's position in this regard." You take note of that.
I see that, Chair.
Thereafter, there is another email then that comes in from, on page 33, it is now from Tintwalo Makhubele, sent Thursday 21/2017, 12:15, to Mr. Madimpe Mukhashwa, Sisi Lindikaya Zide, subject arbitration for Siaya Prasa. Dear Mr. Madimpe, thank you for the update. Mr. Zide, please attend to finalize the matter. Then it goes WRT, payment part. You see that?
I see the email, Chair.
Mr. Mukhashwa, was there any payments made by Prasa to Siaya?
You mean at this stage, 21st of December?
At this stage, yes.
No, I doubt that. Because subsequent to this, there were inquiries about payments. So as at 21 December 2017, I believe Prasa had not made any payments.
Okay.
It's the same date that the offers, revised offers, went out anyway.
When was the next time you dealt with these matters?
Beyond the 21st.
Beyond the 21st of December 2017, when was the next time you dealt with these CIA matters?
I can't remember, but I think I've had to field inquiries from CS legal representatives about the payments that continued to be outstanding up until sometime in the new year, meaning 2018.
I'm going to refer you to your affidavit on page 17, volume 11A, paragraph 36.
I'm on it.
It says that on 8 January 2018, we received a letter from our opponents regarding their proposal in respect to the outstanding matter with case number 74281, stroke of 2015, and they attached it. I'm going to refer you to page 34 of your affidavit, the attachments. Same volume, page 34.
Yes, I'm on it.
Is this the letter that you received? Dated 8 January 2018. It is addressed to yourself.
It seems to be the letter that the affidavit refers to, yes.
In regards to paragraph 1 of that letter, they query the payments in regards to their correspondence of 18 December 2017.
Yes, the letter seems to say that payment is awaited still.
And they further go on to indicate that in regards to that case 74281, we received instructions from our client to direct your attention to the following, and then they set up certain issues. But let us confine ourselves to the top part matters. Is it correct that by the 8th of January 2018, PRASA had not yet paid Siyaya on the, based on the settlement offers that had been made?
As at that date, the 8th, yes. I doubt that PRASA had made payment.
Okay. Was there any further correspondence that you received?
Yeah, I may have continuously gone on to receive inquiries from Mr. Matopo. And I think I was at a point of explaining that at some point, the legal representatives of CIA approached me with, well, to express their intention to proceed to have the settlements made, to continue to have those settlements made awards by the arbitrator. And that as a result, they were simply merely giving me courtesy of their intention to do so, and that obviously my client's cooperation would be sought for that to happen.
The further correspondence that you have referred to, would it be the correspondence on page 37 of that volume? Can you have sight of that document, please?
I'm on page 37, Chair.
Is this the further correspondence that you received?
Yes, it would be. The letter dated the 17th. And I see that it's addressed to the arbitrator, Mr. Justice F.D.J. Brandt.
Now, I want you to go to paragraph 1.6 of that, on page 38. 1.6 of that correspondence.
I'm on, Chair.
Can you please quickly read that?
Okay, it goes that in the unlikely event that PRASA fails or omits to effect payment of the aforementioned amounts on or before Friday, the 19th of January 2018, our instructions are to approach you and disclose the terms and conditions of both settlement offers to you and to request that you make an award in terms thereof, specifically to enable our clients to initiate an application to the High Court of South Africa and to apply for an order as envisaged in Section 31 of the Arbitration Act.
You say that this correspondence was brought to your attention 17 January 2018 on page 37.
It must have been brought to my attention. I think either I was copied when it was communicated, or Mr. Matoba must have gone on to make a copy available to me.
Did you bring this correspondence to the attention of Mr. Zide, whom you had been instructed to communicate with?
I must have gone on to do so, yes.
I want to refer you to page 41, further correspondence by Matopo attorneys.
I'm on it.
Did you receive this correspondence? It is dated 29 January 2016. It is addressed to the Honorable Mr. Justice F.D.J. Brandt.
Yes, Mr. Matopa must have gone on to make this copy available to me.
And did you bring this correspondence to the attention of Mr. Zide?
Naturally, I would have gone on to do so, yes.
Was there any response?
Not that I can think of.
Okay. Now, I want to take you to page 44 of that volume. Sorry, Chair. Before we get to page 44, sorry, mine. You say there was no response to this correspondence dated 29 January 2018
Well, yes, not around that date.
from Mr. Zide.
Not yet from Mr. Zide.
If you say there was no response around that date, was there any response further on?
Yes, there must have been, because at the time, I think around this time, Advocate Bottas and I were, or at least he was communicating with me to inform me mostly that he was trying to track down the movements of Justice Brown. Justice Brown was due to be in Gauteng, I think, around February, and he proposed to me that it was his idea that we go see him when he was in Gauteng for some of the matters he was busy with.
Did you go?
Yes.
Sorry, no, you can proceed.
I then went on to communicate all of these developments to PRASA, because any agreed to process to approach the arbitrator for reasons as advanced in the letter of the 17th to Judge Brandt would have required me to do so with the instructions of PRASA.
When did you see Judge Brandt?
It may have been on the 7th or on the 8th, because if I look at page 43, I think it's WhatsApp or text messages between Mr. Zide and I got the confirmation to take part in the proceedings on the 7th of February 2018. So I can't remember whether it was on the same day or that we went to see Judge Brandt the day thereafter.
Okay. I'm going to refer you to page 18 of your affidavit, paragraph 38.
I'm on page 18.
Paragraph 38, line number 6.
The one that starts with although initially.
Yes,
Must I read it out?
you can read it out.
Although initially Advocate Bottas had arranged to have the parties appear before Judge Brandt on the 5th of February 2018, the final arrangement was made to have the parties appear before him on the 7th at 1300 hours in Pretoria. At this stage, our office had already briefed PRASA of the intended meeting with the judge as arranged by opponents, and that the draft awards had been availed to Mr. Zide for urgent consideration and instructions.
Please bear with me, Chairperson. My file is a mess. But be as it may, the draft awards, so in other words, these had been drafted and brought to the attention of Mr. Zide. Now, what was Mr. Zide's response to that?
I think the response finally you see on page 43. I think it's, I'm not sure which annexure it is.
It's volume 11A.
Yes, paginated page 43.
Please, can you read it out?
It reads 7 February 2018, and it's a message from Mr. Zide. It says, yes, Makhashwa should confirm that the settlement be made in order and proceed with arbitration on the one that had outstanding issues. That's from the chairperson. I imagine that Zide simply forwarded what the chairperson had said to him. And then he explains that that's the message from the chairperson.
Thank you. Were these settlement offers then made arbitration awards on the 7th of February 2018?
Yes, indeed so. Mr. Bottas and I went on to see Judge Brandt, and we made representations as was required. And I think Judge Brandt went on to confirm that the settlements were now orders of the, or awards of the arbitration.
Was this communicated to Mr. Zide?
I would have gone on to then provide such awards to Mr. Zide.
Okay. Did you receive any response in regard, or any further update from Mr. Zide with regards to the payment of same?
Well, I imagine that the only feedback I would receive would be when I make inquiries about payments, and that will be because my opponents will be in contact with me to inquire about same.
What happened after the 7th of February 2018 in regards to these matters?
You mean other than that, there was communication about payments?
After the arbitration awards had been made, what happened thereafter?
Well, I presented them to PRASA for payment. I would have gone on to normally then field those inquiries by opponents or representatives of CI about payments. And to the extent necessary, I would have gone on to make inquiries with Mr. Zide about payments. Until sometime, I think early in March, we received applications from CI attorneys, which applications sought to make the arbitration awards orders of court.
I'm going to refer you to page 44 of volume 11A.
I'm on it.
There's an email there from Ncebekazi Mbembe, and it was sent on Wednesday, 21 February 2018 at 17:54. It is addressed to Izide at Prasa L. Matimele. You are CC'd in that email together with Mapule and Amali. Do you see that?
I see that, yes.
And in that email, it's the subject is CI Passenger Rail Agency of South Africa, and there's attachments that are there. You indicate, we transmit here with copies of the applicant's revised notice of motion applications, in terms of which they seek to make the arbitration awards by Judge Brandt, orders of court. the revised applications were served at our offices on even date. Kindly be advised that these applications have been provisionally set down for hearing on the unopposed roll of the 9th of March 2018, and further that if we intend on opposing same, we should do so on or before 1 March 2018. Kindly advise whether you would want us to oppose these applications or simply let same proceed on the basis that they are unopposed. We trust that the above is in good order and await your earliest instructions thereto. And that is the email that Ms. Ncebegazi Bebe sent to Mr. Zide. Do you confirm that?
I confirm, yes.
Therefore, meaning that these notice of motions were received by you on the 21st of February 2018.
Or not before, it may have been on the same day.
And you requested for instructions in regards to these matters.
Correct, we forwarded them to clients for their further instructions.
Were there any responses?
No, we were never given any instructions around these applications.
Okay. Was there further, did you further deal with this matter in regards to that, notice of motion application intending to make the arbitration awards court orders? Did you further deal with the matter?
I think the next thing that happened, I think it may have to be accepted that I kept on trying to get some sense from clients regarding what must happen with the applications. Sometime I got a call from Mr. Dingizwayo, who inquired about what he had heard about these matters, that there were applications in respect of the CII matters, which applications sought to make the arbitration, to confirm the arbitration awards in the High Court, and whether in fact what he had heard was correct or not. And I confirmed with him that yes, we were sitting with 4 applications.
Yes. What else? What else did the conversation entail?
He requested that Mr. Zide, during that call, requested that I make available to PRASA, to him, all of the relevant applications that we confirmed we were in receipt of, which is what we went on to do.
And was this accordingly done?
Yes, I believe my office went on to do that. I'm not sure which.
I'm going to refer you to page 45. 45, an email from Ms. Ncebegazi sent on Monday, 5 March 2018 at 14:56 to Fani Dingiswayo, yourself, Mapule, and Amali. Do you see that?
Yes, I see the email.
And, excuse me, Chair. Then in the body of the email states, good afternoon, Mr. Dingiswayo. We refer to the above matter as well as your even dated telecon with Mr. Mukhashwa of our office. Kindly find herewith copies of this correspondence regarding the set down of the motion applications in these matters and which was previously transmitted to Mr. Zide's office. We trust the above is in order.
Yes, I see that.
At this stage, Mr. Mukhashwa, did you inform Mr. Dingiswayo of everything that had transpired regarding the settlement office, the arbitration awards? Did you inform him of all these processes that had taken place?
I think in that telephone call, I must have taken him through the various processes that had been undertaken by both parties to get to where we were now with the applications.
After he had received these documents, was there any engagement between yourself and the legal team at PRASA?
You mean after I had given them the copies? I think what then followed was a request that I attend a meeting. I can't remember the date of the meeting, but I was called into a meeting at the PRASA offices where Madam Ngoye, Mr. Dingizwayo, Mr. Zide, I think Mr. Mlepo also were all there. I attended the meeting with my colleague, Ngabeka Zimbebe.
I'm going to refer you to page 20 of your affidavit, paragraph 42.
I'm on it.
Is this the paragraph wherein you deal with the issue of this meeting?
Yes, and I see that it says that the meeting happened on the 8th of March, 2018.
Can you just, excuse me, Chairperson, can you please just tell us, excuse me, can you please just tell us what was actually discussed at the meeting? Can you just, from your recollection, what was discussed at this meeting?
All right, I think Ms. Ngoye was doing most of the talking about the purpose of the meeting, and she went on to say to all of us that it had come to their attention that settlements, or our office was previously instructed to make settlements, which settlement proposals then went on to be accepted by this group of companies, and that we acted. And I think she was more giving the Mr. Mlepo, who it would seem was then the acting CEO, feedback that the settlements took place in circumstances where, or on the instructions of the chairperson, Judge Makhubele, and that the chairperson was not authorized or did not have the authority to have PRASA enter into those kind of settlement and settlement processes that led to the settlement themselves.
Thank you.
I could gather from the meeting that there was some intention on the part of, at least in as far as Ms. Ngoye is concerned, that there was, or they were going to make attempts to oppose the applications which at the time were scheduled to take place on the 9th of March 2018. And I think she wanted the acting CEO at the time to authorize that she proceeds to do so.
Tell me, sorry, Mr. Mukhashwa. You say you gathered that there was an intention to oppose the application. Was there an indication that this, in fact, would be done?
I think it was clearly expressed that they were going to do it because they told me that they, for that purpose, they would want to use a different law firm, given that our firm had been part of the processes up to that point, and that it wouldn't make sense for the same law firm to now come through to oppose applications which were about awards that we were a part of.
I just want to take you to paragraph 42, page 20 of your affidavit.
I'm on it, Chair.
In the last line of that paragraph, you stated it was considered that our firm would be conflicted to deal further with the instructions necessary because we were instructed to engage in settlement engagements with the CIA group and when there was no authority to do so on the part of Ms. Makhubele. Is this what in fact was said at the meeting?
That is what was said at the meeting, yes.
Now, this meeting of the 8th of March 2018, Mr. Zide, whom you had been instructed to communicate with, was he ever invited to that meeting?
I think it was, you mean the meeting of the 8th
Of March 2018?
of March 2018.
Yes.
He was part of the meeting. I
Mr.
think he was
Zide.
present there, yes. I do say that in the same paragraph 42.
Okay. What was Mr. Zide, did Mr. Zide say anything at this meeting?
Not anything that I can recall at this moment.
And
Just give me a minute. Zide was present at this meeting,
Mr. Zide was present, yes, Chair.
the 8th of March, 2018,
Yes.
when Ms. Ngoyi pronounced that PRASA did not instruct Judge Makhubele or gave her the authority to settle these matters.
Yes, Mr. Zide was present when Ms. Ngoye
Yes.
was expressing herself as such.
What did he say?
I can't recall that he responded. I think the things were said by Ms. Ngoye, not in a way that it was a discussion between her and Mr. Zide or any of us. I think she was giving the acting CEO an account of what she had been told, the various activities that were taking place up to the point that the applications were brought. So it wasn't in a way that she sought to establish from Mr. Zide or invite his comments around what she referred to as instructions without authority on the part of the chairperson.
Well, even if she was simply giving the now acting chairperson, Molepo, what was going on, she did say in the presence of Mr. Zide that there was no proper instructions to the judge, Makhubele, to settle the matters.
Correct, that she said.
Yes, and there was no response from Mr. Zide.
There was no, at least as far as I was present at that meeting. I don't know what else they further debated in my absence or before I came through to the offices. But I think during my presence at the convened meeting, Mr. Zide did not respond, at least to my knowledge,
Yes.
to what Ms. Ngoye was presenting to Mr. Mlapo.
Now, just on that point, if you can just put a forefinger on it, as they would say in the old days.
Yes.
You had received instructions from Mr. Zide, did you not, confirming that the matters had been settled?
I had been receiving instructions from Mr. Zide about the settlement or the settlements themselves. Remember, in the meeting of the 15th, I was advised that instructions would, from that time onwards, come from Mr. Zide's office.
Yes.
And that is why Mr. Zide's office was the only office I interacted with since that instruction.
No, but what I'm trying to get at on your evidence, Zide would have been well aware that instructions had come at some stage from PRASA to you that these matters must be settled.
Instructions, in fact, came from him.
Yes.
Because when I asked for written instructions, it's a letter that he wrote himself
Yes.
that was addressed to me to settle the matters.
And here was Ms. Ngoyi saying to a meeting that there had been no instructions to settle this matter.
That there was no authority.
No authority, yes.
Correct.
Well, no authority, therefore there could have been no valid instructions.
I imagine that is what she was trying to say.
Well, she wasn't trying to say it, she was saying it.
I accept that, Chair.
Yes. How did you respond?
I was a bit in shock and somewhat frustrated by the developments. I was too happy to withdraw as the attorney of record at the time.
Why?
I agreed with the assertions that somewhat my firm was conflicted because we had always been acting on what we thought were proper instructions from PRASA regarding what we were instructed to do. As a colleague to Mr. Matopo, I can't imagine that there would be a plausible explanation on my part about why then I was the very same attorney then opposing applications to have the settlements or the awards made orders of court. It would have become an uncomfortable position for me to be in. So I was somewhat relieved that the decision was to instruct another law firm.
Yes. Thank you.
Thanks.
Did you accordingly withdraw from the matters?
Yes, Chair, I think we went on to withdraw, and paragraph 43 of my affidavit says we went on to do so the same day, on the 8th of March 2018.
I just noticed, sorry, the way the affidavit is drafted. It reads, our firm accordingly withdrew as attorneys of record for PRASA in the, and settled is, well, in italics, matters that the point would become disputed, matters in the application in court, and this we attended to on the 8th of March 2018. Why did you put it in that particular way when it's clear you drafted the settlement office?
Yes, I think the point perhaps I was trying to make by making settled in italic is, or at the time was, because we were not asked to withdraw on all CIR matters. We were asked to withdraw only in respect of the matters where offers were tendered, subsequent to which there were acceptances, and then we went on to make them awards of the arbitrator. There was and you would recall when we were going through part of my evidence that the arbitration proceedings were postponed rather from the 11th of September to some date in March. So at this point in time, PRASA had thought that our firm would continue to deal with the remaining matter that was not part of these settlements in the ordinary course. Thanks.
Mr. Mukhashwa, at this meeting of 8 March 2018, was there anything that Mr. Zide ever said at that meeting?
Not that I can recall.
Okay. The correspondence dated 15 December 2017, which was referred to you earlier on, and this is the one found on page sorry, Chairperson, it's found on page 272. Volume 8, sorry, Judge Mashidi, Volume 8, page 272.
Yes, I'm on the page, Chair.
Are you aware that this correspondence found its way into the hands of Advocate Boetes?
Well, to the extent that he testified around it yesterday or day before, yes, I'm aware.
And when did you become aware of this? Just yesterday during his testimony?
Indeed, because he confirmed that it was sent to him. If I'm not mistaken, it was part of an attachment that he had received from Judge Makhubele.
Okay. Chairperson, that brings me to the end of my examination in chief of Mr. Mokhasho.
Thank you, Chair. Chair, with your leave, may I follow up on the last set of questions you posed to Mr. Mokhasho about the meeting which he attended on the 8th of March, indeed. Mr. Mokhasho, you talk about that meeting in volume 11A, page 20, paragraph 42.
I'm on it, Chair.
And you would recall that the chair asked you questions around what Ms. Ngoye said at that meeting. You remember that?
Correct.
She said something more than the mere fact that the chairperson of the board at that time did not have authority to conclude the settlement. If I read what you say in your affidavit, you also say that, according to her, the settlement was unlawful ab initio, by which I assume you know that she says the settlement were invalid from the beginning, correct?
Correct.
Now, she came to testify here, and we asked her questions. I would not bother you about what her version is, but I'd like to take you to what you yourself knew about that settlement. And you seem to talk about your knowledge of the settlement and the instructions you got around it at page 14, paragraph 29 of your affidavit.
I'm on it, Chair.
You will see that, I'll read it out and I'll tell you where I would like to pick up your evidence. You open up by saying the following. On 15 December 2017, I attended a meeting at PRASA's offices in Hatfield and was received by Ms. Makhubele and Mr. Zide. Members of the group legal team were not present at this meeting. Ms. Makhubele kicked off by mentioning to me that PRASA had taken a decision that Siyaya Group matters with PRASA were now being dealt with by the PRASA board. Do you see that?
Yes, I do.
First thing first, you confirm that so far as you recollect today, that's what Judge Makhubele told you?
Yes. That's
That
what.
those matters henceforth will be dealt with by the board, correct?
Correct.
And I suppose that you knew what that meant in terms of the hierarchical decision-making in PRASA. In other words, it will be the board which will deal with those matters and make decisions on it.
Correct, that's how I understood it.
And that would not have surprised you why the legal team would not have been there to make decisions on those matters. Once you get to know that the board will deal with them, correct?
I got to understand their absence at that meeting.
Thank you. And then the affidavit continues as follows. Ms. Makhubele kicked off by mentioning to me that PRASA had taken the decision that Sierra Group matters with PRASA were now being dealt with by the PRASA board, and that I would receive relevant communication and instructions by the board through Mr. Zide. Do you see that?
Yes, I do.
So on the ground, it will be Mr. Zide who will be communicating with you, correct?
That's how I understood it, yes.
And you have testified about the discussions that you had with Mr. Zide, culminating in that letter of instructions about the offer, correct?
Correct.
And that is a matter around which you would have had no surprise at all, because you were told at that meeting that it will be Mr. Zide who talks to you about the board's position on this issue, correct?
That is correct.
Yes. Now, you would understand that Ms. Ngoya is not a member of the board.
I understood it that way, yes.
Yes. And she came here to tell the chairperson about meetings of the board that she did not attend. I would not bother you about her version. The simple point I'd like to make and ask you to comment on is when she told you at that meeting of the 8th of March that Judge Makhubele did not have authority, did she tell you where she got that assumption from? And I put it no higher than an assumption.
Well, I understood what she was saying to be that Judge Makhubele was not authorized to give me the instructions she did on the 15th of December. I can't say to you now that I'm certain what her basis of having said so was at the time, except to listen to her saying it in front of Mr. Zide, in front of Mr. Mlepo, and I believe that at the time he may have been the acting CEO, and to accept what she was saying as she was saying it.
No, Mr. Mahasha, I understand that you understood what she said to you, but my point is slightly different. This was a remarkable thing that she said at that meeting in your presence, in the light of what the chairperson and Mr. Zide said to you at that meeting of 15 December 2017.
Correct.
And in fact, you have confirmed that you were shocked by it.
Yes, indeed so.
Question is, did she tell you what is the basis of the assumption she made in that regard?
No, we did not go into detail about that.
But that's a far-reaching proposition she made to you in your presence, around which, in fact, we now know she decided to instruct a different set of lawyers to go to court and oppose the application to make the arbitration awards orders of court.
On the 8th, when I was at the meeting with her and her other colleagues, there must have been pressure to try to act very swiftly in order to be ready to oppose the matters the next day. Other than that, she mentioned that Ms. Makhubele did not have the authority to instruct our firm to make the offers we did. I'm not sure what the detail is of her basis to have arrived at that conclusion. One imagines that is information that possibly would have formed part of their basis of opposing the applications. And I never got any wind of the nature of the papers they filed.
Yes. Yesterday we listened to Mr. Bottas as he testifying on how the proceedings on the 9th of March evolved. And he confirmed that there was not even the slightest of affidavit placed before the courts to explain the basis of opposing the 4 applications which Mr. Bottas dealt with. But the point for you is, did anyone consult with you with a view to formulate a substantive basis to oppose the applications that were set down for the 9th?
Well, in honesty, I thought I would be consulted with, but the only extent to which I was contacted about the matters after we had withdrawn was that I signed a confirmatory affidavit, and I was given a portion of Ms. Ngoye's affidavit that had to do with me. And I went through that extract, and to the extent that I found happiness with it, I went on to give her my confirmatory affidavit. I doubt that that affidavit served on the 9th when they were opposing the applications. Perhaps later on, when other applications came up, I was contacted to simply confirm what she had stated about my involvement in her affidavit. I'm not sure whether it was a rescission, an affidavit about the rescission application, or what that affidavit was what purpose it was meant to serve. I'm not sure about that at this juncture.
Well, I mean, the only affidavit I know which Ms. Ngoye executed, which is part of the bundle of documents we have in relation to the settlement matters. Ignore for now the affidavit she made in the Zondo Commission, but in court was the application for interim interdict, as well as for the rescission application. If you want me, I can take you there. You will find it at volume 8.
Yes, Chair, which page?
It begins at page 9. You'll see that the preceding pages from 1 to 6, it's a notice of motion. But her affidavit begins at page 9, and you'll see that her name appears on page 10.
Correct, I see that.
Yes. Is this the affidavit to which you were called upon to give a confirmatory affidavit?
I didn't see all of it, and therefore I can't confirm. What I remember, Chair, is yes, some extract of some affidavit was sent to me, and I was asked to consider it and indicate if I was happy to confirm the contents or the paragraphs in as far as they had to do with our firm, which I did. So I was not given, or I did not go on to ask for the rest of the document.
Yes. In this affidavit, one of the grounds she relied upon to seek the relief for Part A and Part B was the fact that the settlements that you were involved in were secret settlements. I wonder whether you know about that.
I may have commented about that. They were, well, I'm not sure if you're saying secret meetings or secret documents.
No, she said she'd identify them as secret settlements.
Oh, secret settlements.
Yes.
I may have made the point when I was at the State Capture Commission that we were never involved in any secrecy to do with the settlement of the CII matters, because these are instructions I received from PRASA after meetings I had been invited to at PRASA offices on the 4th and particularly on the 15th of December. So I may have disputed that fact that I was involved. If there were secret meetings, I was not involved in those meetings. The only meetings I was involved in would be the meetings of the 4th of December and the 15th of December, 2017.
Yes. I understand that the point for now is that the affidavit you made to the Zondo Commission investigators is dated 19 May 2020. You'll find the date in volume 11A, page 21.
Correct.
And in it, you do dispute the version of both Mr. Dingizwayo and Ms. Ngoye before the Zondo Commission, that there was a secret settlement. And you do so from page 8, paragraph 17 of the in fact, let me take you back. You do so at page 5, paragraph 8 of volume 11A.
I'm on the page, Chair.
And you say there, in respect of paragraph 38 of Mr. Dingizwayo's affidavit, I wish to categorically state that I and our firm have never been part of any secret settlement. Do you see that?
I see this, yes.
All our dealings in this matter have been transparent, and we acted on written instructions from PRASA officials. Do you see that?
Correct, Chair.
And at some point, as we talk about this, I'll take you to your transcript of the oral testimony you gave before the Zondo Commission, where you stand by this version. But for now, the point is that by May 2020, when you executed this affidavit, you made the point to the Commission that you were not involved in any secret settlements.
I suspect what happened then at the time, Chair, and I think, yes, it was in the State Capture Commission. I must have been provided with copies of Ms. Ngoye and Mr. Dingizwayo's affidavits, and that I come up with mine by giving regard to what they state, and that I provide evidence about matters that involved me or our firm in the conduct of the CI matters.
I understand. Your testimony before the Zondo Commission was public, correct?
Correct.
And what you said there would have been a matter of public notice, correct?
Yes, indeed so, sir.
So both in your notice and public testimony, you deny any suggestion that your firm was involved in a secret settlement.
That is correct.
The point that I'd like you to explore, if you can, and help us if you could, you can, is that despite your public denials of involvement in secret settlement, Ms. Ngoye, before Judge Tuchten, still stands by the claim that there was a secret settlement.
Well, I suppose that is her opinion about what she then, what she at the time, and perhaps we should talk about the period around early March of 2018. Whatever she had come to know, which I presented to them about the period between December and March, to her, its activities that took place in secrecy, and that may very well be so because I had said to them on the 15th of December that I was asked to deal with the office of the CEO only because the matters were now in the hands of the board. I can imagine that it's in that context, and I can't take it any further than that.
Mr. Mukhasho, I suggest to you, by any stretch of imagination, that cannot be secret. Your engagement with Mr. Zide can hardly be secret because it was documented.
I think we're saying the same thing.
Yes.
I disputed that there was secrecy around my dealings with the chairperson or the office of the CEO.
Yeah. Well, I'd like to round up my questions on this issue by asking you this. You know that PRASA has a delegation of authority instrument, correct?
I suspect so. I think
No,
most
but-
of these entities would. I've never seen a power of delegation instrument, so I'm not sure if I should say yes, I know or not.
But Mr. Mukhasho, I mean, you have acted for PRASA for quite a long time.
Correct.
And the Siaya matter were not the first of its own kind, of their own kind that you represented Siaya, PRASA.
Indeed so.
Yes. If you don't mind, I'd like to, I would invite you to look at a report of the Auditor General, and I don't want to comment on the numbers, but simply on the fact that the Auditor General made certain observations about your relationship with PRASA. When I say your relationship, I mean the relationship of your firm with PRASA. Okay. The easiest thing is also to look at the internal audit report. It's at volume 16 of 1.
Do I have the volume? I've got volume 11.
I'll ask the points person for us to point it to you.
Okay. Volume 16 of 1, that's what
Yes.
I have in front of me.
Can you go, please, if you can, to page 212?
I'm on page 212, Chair.
You will see that there's a table, and the heading of it is Top 10 Legal Panelists by Rand Value. Do you see that?
I see.
And I see that your firm is the second after Worksman's Attorneys. Do you see that?
I see that, Chair.
And you will see that it tracks and traces your firm from years 2016, 2017, 2018. I don't want you to confirm or talk about the numbers, but I simply want to ask you to confirm that as at those year ends, you had been performing work for PRASA.
That's correct.
Yes, thank you. In that context, I really wanted to confirm with you whether you have ever seen the delegation of authority of PRASA in the course of your legal services that you provided to it.
I may have in some of the matters we assisted PRASA with.
And as I say, the delegation of authority is in volume 8 if you want to see it, but the proposition I'd like you to comment on is that it sets out in clear terms the powers of the board to manage and direct and lead the management of PRASA. And it also makes it clear what of those powers the board had delegated to various of its functionaries and organs. I take it that you are aware of that.
Correct.
And one of those functionaries is the group chief executive of PRASA. And we have explored this issue with Ms. Ngoye, that the board had delegated to the chief executive officer the power to settle cases that PRASA is involved in Are you aware of that part of the delegation?
I can't particularly say I'm aware of that part of the delegation now.
I'll have to take you to it
No.
and ask you to comment on it. If you don't mind, can you go to volume 8, page 75?
I'm on volume 8, page 75, Chair.
You will see that there is item 40,
I see that, Chair.
and you'll see under item 40 there's small paragraph D. Do you see that?
I see that, yes.
Page 75 of volume 8. And you'll see that paragraph D says, to settle any claim by or against PRASA or dispute with PRASA, whether or not proceedings have been instituted. Do you see that?
I see that, Chair.
And you see that the level of accountability has been given to the group chief executive officer.
I can see that on line 40, Chair.
Yes. Is this the first time you see this delegated power, or have you seen it before?
I may have seen it before, but I can't quite say I'm familiar with this particular copy or version.
Chair, I think I've explored the follow-up questions. I'd like to go to my own questions now, if you don't mind. Yes. Mr. Mkhasho, I mean, before you met, when you met Judge Makhubele at PRASA in December 2017, you had known her before and you had met her before. Is that correct?
That's correct.
Can I ask you to go to the transcript of your oral testimony before the Zondo Commission? And it is at page 109, volume 11A.
11A. Okay. I'm on page 109, Chair.
109.
109, yes.
Yes. You will see that the transcript records the following at the end of that page. You speaking, personal interactions, yes, when she was an advocate of the Pretoria Bar Council, I have had to work with her when I was at the previous law firm. I used to be a partner at Heldenays Malachi. That was a reasonably medium-sized firm, as far as I know, around 2017. Correct?
Well, in Pretoria terms, it may have been a large firm, but yes, broadly
Yes.
medium-sized.
My apologies to confuse the scales of legal competitive services in Sandton and Pretoria.
You've got one side of Jackskay and the other side of Jackskay.
Yes. And I take it that you may have had an opportunity to brief Advocate Makhubele when you were a partner of that firm.
That is indeed so, Chair.
And I assume that you trusted her legal skills when you briefed her.
That is indeed so, Chair.
You trusted her professional judgment.
That is indeed so.
You trusted her ethics.
That is correct.
And I mean professional ethics.
That is correct.
Yes. And just as a matter of illustration, how often did you brief her when you were still a partner there?
It may, put me on the spot because I may be judged on that, but we were quite, one matter I will not forget about was a trial that ran for over 3 weeks. I think it was a road accident fund case. I appointed her, I think Judge Makhubele at the time was a junior counsel. I appointed her with, I think, the late Pete Kemp as the senior counsel. And it was an instruction we were dealing with on behalf of the Road Accident Fund against, I can't remember whether it was Adams and Adams or one of the law firms that ordinarily would do work for plaintiffs in the third-party compensation matters. But yes, I particularly remember that case because of the length, the amount of time it took for us to conclude the issues around the matter itself.
What happened to that matter? Was it settled or was there a court judgment?
I think we appeared before Judge Mybeck, if I'm not mistaken. There was a court judgment eventually at the end.
And so when you met her in December 2017, she was someone that you were personally and professionally familiar to?
Correct.
Yes. Now, what I want to do is to ask you to go to the terms of reference in volume 3.
I doubt that there is volume 3 here. I've got volume 3 in front of me now, Chair.
Can you go to page 1033? 1033.
Yes, Chair, I'm on the page.
Are you at paragraph 5.2?
I can see 5.2, Chair.
And it says, what this tribunal is asked to do is to investigate and make findings, amongst others, on 5.2, whether Judge Makhubele's conduct as a chairperson of PRASA was incompatible with the office of a judge, in that of all the cases that PRASA was involved in, she paid special attention only to the to those of Siaya. You can ignore that for the moment. Next, that she marginalized the PRASA legal unit and terminated or caused to be terminated the mandate of PRASA's attorneys and appointed another firm of attorneys in their stead to represent PRASA. Can I ask that we stop there? You explained that when the Siaya matters were instituted, you were instructed by Mr. Dingiswayo, correct?
Correct.
And that you accounted to her through Ms. Shumi Mukotedi.
That is correct.
Who was also a member of the legal department at PRASA.
That is correct.
Judge Makhubele was not there when you were appointed.
In 2015 and 2016, that is correct, Chair.
And she was not involved in that exercise. What I want to ask you is this. When you were on record for PRASA from 2015-2016, on all those 4 matters, up until you filed a notice of withdrawal on the 8th of March 2018, correct?
Correct.
And your decision to withdraw from the record as the attorney of PRASA was as a result of what Ms. Ngoye conveyed to you about a conflict or possible conflict of interest.
That is correct.
Yes. That had nothing to do with Judge Makhubele.
No, not at all.
Then can I pick up where we left in the terms of reference?
Yes, you may, sir.
That she negotiated with Siyaya's attorneys and entered into a confidential settlement agreement that is manifestly and materially prejudicial to the interests of PRASA, relying on existent, in quote, major concessions, close quote, on its liabilities to Siyaya allegedly made by PRASA's employees at the insolvency inquiry. Let's stop there. Yesterday, Advocate Botes came to testify about his interaction with Judge Makhubele, and that included presentation of several documents to her in a bundle that was attached to his affidavit. I do recall that in the Zondo Commission, Mr. Botes testified before you did. I don't know whether you are aware of that sequence of testimony at the Zondo Commission.
Well, I had heard that he had gone through the commission at the time that I was invited
Yes.
to go give evidence, correct?
In fact, when you testified, there were exchanges between the evidence leader, Advocate Soni SC, and the chairperson about prior testimony that Mr. Botes had given, which was debated in the course of your evidence. You recall that?
I can't quite recall that.
Well,
but
that's fine, then
possibly that's what happened, yeah.
I don't think it's a major issue. I simply want to give you context about how the evidence unfolded before the Zondo Commission, because it becomes important in these proceedings. The affidavit of Advocate Botes and the transcript of the evidence he gave to the Commission appear in volume 19. I wonder whether you have had occasion to look at that affidavit and its attachments.
Now, I've got volume 19, but I am yet to go through Advocate Botes' affidavit.
But again, the sense that you know what he said yesterday when he testified.
I managed to listen to most parts of his evidence, yes.
You will see that his affidavit begins at volume 19, page 45. You'll see that it is marked X for the purposes of an inquiry by the Pretoria Bar Council.
I'm on page 45, that has got X.
Yes.
On top right, yeah.
And part of the attachments to that affidavit is Annexure B, which begins at 65. That is the report prepared by the Commissioner of the 417 inquiry into CIR DB in liquidation Do you see that?
I see that, yes.
That is a report that you say that you called for and were not given a copy. You remember that?
That's correct.
And then furthermore, part of the annexures to that affidavit is an email that begins at page 76. It's a fairly longish email. It spans up to page 79. No, up to page 80, my mistake. Do you see that?
I see that.
Yes. And his version is that he gave these documents, in other words, the report and the email, to Judge Makhubele. Now, I'd like to focus on the email, if you don't mind. It begins at page 76, as I said, and you'll see the date is 6 September 2017. Do you see that?
I see that, correct.
And in context, this email was written after the proceedings of the 417 inquiry had been concluded. My recollection is that those proceedings took place in August 2017.
That may be so. You would recall that we attended, I think, on 2 occasions, so I can't quite make out whether on the last day we attended, that was the last day of the sessions to be held.
Yes.
In that commission. So I'm not sure exactly, precisely from which date up to which date the hearings ran.
Yes. I will take you in due course to what the witnesses of PRASA said in those proceedings in your presence. But for now, I simply want to confirm with you that the email, which appears from page 76, was written after the proceedings of the 417 that you attended.
I take the point.
Yes. You will see that it is from Mr. Botes, by which time he was familiar to you, and it is dated the 6th September 2017, addressed at 10:10, 26 seconds in the morning, and amongst others, it's addressed to you. Do you see that?
I think in the main it is addressed to me.
Yes. And a number of people have been carbon copied there, including your colleague, I'm sorry, my apologies, your colleague, Ms. Mbekazi Mbebe. Do you see that?
Yes, I see that.
Yes. And I see that it has also been copied to Mr. Kennedy. Is that Mr. Tatawani?
It will be Mr. Tsawani, yes.
Yes. And he says, "Dear Madimpe," and I take it that is you. Do you see that?
Yes.
Can I confirm with you that you received this email?
I saw it this morning, and I want to believe that this is what was sent to me on the 6th of September, 2017.
Yes. And I take it from that response that you received it as a fact.
I have not, I didn't find enough time to go through, well, during the proceedings of yesterday, I couldn't figure out what the date was of this particular email that he referred to. I got to see the actual email this morning when I was preparing to come give my own evidence. No amount of asking my office to look for this communication would assist because I was here already.
Yes, I understand. But certainly if you did not receive it, Ms. Mbebe would have received it.
Yes, yes. So I do not dispute that we may have this as part of what we have in the past received from Mr. Portas.
Yes, thank you. And he says, thank you for the comprehensive letter. Kennedy and I discussed this issue comprehensively on various occasions, and I labored under the apprehension that Kennedy was duly instructed and mandated by you and your client to agree to a postponement. It seems that Kennedy, in quote, went on a frolic of his own, close quote. If it is your client's instructions that the arbitration should proceed on Monday, so be it. There is nothing that I can do to persuade your client otherwise. You will see that at that point, the bone of contention between you and your counterpart and respective clients was whether the arbitration that had been set down initially before Judge Brand should be postponed or not.
Correct.
What happened to that arbitration? Did it proceed or was it postponed?
I think eventually we agreed to a postponement. Perhaps what he's expressing in paragraph 1 of this email to me is the fact that he had thought, as he was talking to Kennedy Tsetsawane, that there was some agreement or at least instruction from PRASA that the proceedings that were meant or scheduled to run from the 11th of September be postponed, which instruction at this time I didn't have. And I must have written to him to say there is no instruction from PRASA that the matters be postponed. If he wanted us to present to PRASA that the matters be postponed, we would do so, upon considering the reasons for him to want us to postpone the matters.
But eventually it was postponed. And
Yeah.
I take it that you got instructions from PRASA to postpone the arbitration.
If the documents are not here, then the arbitration did not proceed, so
Yes.
we must have been given instructions to postpone.
And off the top of your head, do you recall who gave you instructions in PRASA that the arbitration should be postponed?
It must have been Ms. Mukotedi or Mr. Dingizwaya. I think I was dealing with them both at this time.
Yes. And Judge Makhubele had nothing to do with those instructions for postponement of the arbitration.
Not at all.
And then we are back on page 76. And on the third paragraph from the top, I will ask Commissioner Kruger to expedite his report so that it can be discovered in accordance with the provisions of Rule 35. I believe that the record is in the process of being finalized. Once we are in possession of the record, it will be discovered in accordance with the provisions of Rule 35. The record speaks for itself, and we did take up yesterday this part of the email with Mr. Portas yesterday. But for the present purposes and for your concern is what he says thereafter. He says, you were present at the insolvency inquiry and you personally witnessed the testimony of your client's employees and former employees under oath. You and Kennedy witnessed the material and fundamental concessions and admissions that were made by your client's employees and former employees. Do you see that?
I see that, yes.
He is quite emphatic in what he conveys to you in this email. Do you accept that this is the serious, emphatic statements that he conveys to you?
I agree that he's making a point to me very strongly.
Yes. Chair, I'm going to interrupt myself and ask you to go to volume 16 of 1. Mr. Mkhasho, I'll ask one of our colleagues to place before you volume 16 of 1.
Yes, I do have it.
If you go to page 256,
I'm on page 256, Chair.
and you'll forgive me because we were not there and we work off the transcript of the proceedings. At the top of page 256, you will see the date is 24 August 2017. Do you see that?
I see that. Yes.
And the commissioner introduces the inquiry and its purpose to all those who attended. And you'll see that Mr. Botus acknowledges his presence. Do you see that?
Yes, I see that.
And he also recognizes the attendance of Matopo. Do you see that?
I see that, yes.
And then below, he also recognizes the presence of Mr. Makensa Mabunda. Do you see that?
Where do I find that? Which page?
After Matope, if you go down, you'll see Advocate F. W. Botus, Inc., yes, as well as Krause, Inc. And I will lead the evidence of witnesses who were subpoenaed to be present for the duration of this inquiry. On my left, also present is Mr. Makensa. He spells the name, and his name is Mabunda. Do you see that?
I see that, yes.
And then if you go down the page, you will see that he begins to introduce Mr. Tsatsawane. It's more or less the 10th line from the bottom of the page.
I can see that, yes.
He refers to him as Kennedy, and the commissioner asks his surname, Tsatsawane. You see that?
I see that, yes.
And then over the page onto at 257, the third top line, Mr. Botus mentions that Johannesburg Bar, I have invited Tsatsawane SC to be present when the witnesses are being led. The reasons being, Mr. Commissioner, and the commissioner interjects, I wonder, shouldn't he be sitting in while you are? Very well. Yes, very well. Let us call him, and let us call him. And so it goes on. And you'll see from the sixth last line, Mr. Tsatsawane speaks to the commissioner. He addresses the commissioner. Do you see that?
Yes, I do.
And he says, I'm with my attorney here, instructing attorneys. And he says, my attorneys, Madipa, apologies for the misspelling.
I'm getting used to it now.
Mkhaswa.
It's supposed to be Madimpe Mkhashwa.
Yes. My apologies. My mother used to call it intellectual laziness.
Well, not on your part, clearly. You didn't come up with these transcripts.
But the point really is that you were present, and your presence and capacity in which you were there were acknowledged by the commissioner, correct?
Correct, I agree with that.
I now wish to take you back to the email of Mr. Botus. Remember, we were at page 76 of volume 11A.
I'm on the
page
page.
76 of volume 11A.
I'm on the page, Chair.
Yes. The last paragraph on that page, Mr. Botus said the following to you and Ms. Mbebe, amongst others. Your clients, Mr. Soren Baltic, conceded Siaya's claim which forms the subject matter of case number 47597/26 in the amount of 21 odd million rand. Your Mr. Soren Baltak undertook under oath to verify and confirm the amount that is due and payable to Siyaya and to revert to the Commissioner Kruge within a week. Commissioner Kruge excused Mr. Soren Baltak and Mr. Johan Edwards to afford them an opportunity to verify the correct amounts that is due and payable to Siyaya. My instructions are that Mr. Soren Baltak verified the amount due and payable by PRASA to Siyaya, being 19.7 million. This amount is therefore not in dispute, and your client should pay it immediately in full and final settlement of the claim in respect of case number 47597/2015. Does your client persist in pursuing the arbitration under these circumstances? Do you see that?
I can see that, yes.
So I understand that you may not have been prepared to indicate to the chairperson whether or not there were major concessions of this kind because you did not have the report and the transcript.
That is correct.
Yes. It's fairly understandable. The key question is this, that your colleague writes to you and asserts these concessions and asks you whether your client at that point in time still wishes to persist in litigating that claim. What I want to establish from you is, did you respond to this email?
I may have acknowledged receipt of it, and as ordinarily things would be, I must have forwarded it to client for their consideration and discussion if they wanted to have a discussion.
Yes.
But I think just to assist you further around it, you would recall that I said there are reports that I prepared for PRASA
Yes.
at the end, perhaps, of the testimony of each of the witnesses. And I see that Mr. Buotas also refers to, I think on page 76, the last paragraph, he makes reference to the fact that Mr. Baltak had undertaken to verify and confirm the amount that was due and that he was to revert to the commissioner. So what possibly then happened after this was for me to write a brief summary to PRASA in which I say to him, Mr. Baltak is expected to get back to the commission on these issues. And this is why I would have loved to have copies of those reports. And had I known that they would become an issue, possibly I would have, taken some effort in finding them. But that is what the report would say.
Yes. I understand. But what Mr. Buotas says to you here is that Mr. Baltak testified under oath. And when you take the oath to tell the truth, the assumption is what you say is the truth.
That is correct.
Yes. And he says, based on what Mr. Baltak has said to the commissioner in the 417 inquiry, the truth as he conceived it was that Mr. Baltak accepted that there is an amount of 19.7 million rand that was owing to PRASA. There would be a need to do further investigation to confirm the precise amount. Now, you say that there were reports that you prepared after this testimony of Mr. Baltak in order to make the follow-up in line with what he undertook to do after his inquiry. I understand that I've not seen them, We will be guided by the tribunal or our colleague for the evidence leader whether or not we should pursue further inquiries in that regard. But for my part, I don't need to do that because I'll take you to one of the reports which Mr. Baltek prepared at the request of the chairperson, which speaks to this issue that is raised by Mr. Botas with you on the 6th of September 2017. Again, the report of Mr. Baltek after his evidence is in volume 8.
Okay, I've got volume 8.
Chair is at volume 8, page 258.
$258, you said?
Indeed.
I'm on page 258.
In the interest of time, we can read it together. Furthermore, the SLL, through the commissioner, asked if I know if there is any outstanding payment to Siaya for the GSMR project. Why and what is the value of the outstanding payment? My response was that there is an outstanding payment for a variation order. Siaya have been asked to assist PRASA to get the most effective deal for the extension of the GSMR contract. The decision for payment has been stopped at higher levels in PRASA due to different opinions regarding the rates charged by Siaya's German experts working on the project. In my opinion, the value of the VO needed to be revisited and agreed. And then he goes on. He says, at the end of the inquiry, I have been asked by the commissioner to check with Johan Edwards the outstanding payment for the resignaling project and to confirm what is the final value for these outstanding payments and to revert in a week's time for the GSMR project. The commissioner asked to consult and agree with Mackenzie Mabunda the value of the VO and revert to him also in 1 week. After the testimony, PRASA's legal department has instructed me not to enter in any discussion with Mackenzie Mabunda or with the commissioner. My involvement by now in this process was finished with the instructions. Do you see that?
I see that, yes.
So that he made an undertaking under oath that he would go and establish the rates and the quantification of the variation order, but someone in the legal department instructed him not to proceed with it. Do you see that?
I see that, yes.
Do you have any knowledge that you can share with us why someone in the legal department, you being an attorney of PRASA, would issue an instruction of that kind?
I'm not aware about all of this or what was at the time happening regarding the interaction between Mr. Baltek and his colleagues at PRASA, except to say that much as he also says the same thing that I'm saying, that there is a report that summarized what he would have had to do in assisting the commission further. And I don't want to take your time, Mr. Malika, but if you look at the email, for example, by Mr. Puotas, when he asks me the questions he is on the 6th, he probably at that time had the benefit of the fact that Mr. Baltek went on to conduct whatever investigations as a result of which his conclusion was there was 19.7 that was outstanding. This information I'm seeing for the first time today, so which means I was never placed in possession of any other document by a PRASA that was intended to assist the Commission further. And this is why personally, I've always been worried that it was important for me to get hold of the report, because the report then would give me some idea where the processes were in as far as the findings of the Commission itself were concerned. Now furthermore, what we were going through just now by Mr. Baltek is dated the 30th of November 2017. So which means this report by him was or had not been formulated at the time that Mr. Bottas wrote to me on the 6th of September. I suppose Mr. Bottas wrote to me and indicated the things he was saying to me because he had possibly captured the testimony of the witnesses far much better than I did, because he was running the processes. So I'm not sure if he said if there was any interim report, for example, as at this time, the 6th. Perhaps there was, I don't know. But I understand why he was raising the concerns to me. I understand why he had thought that I would have similarly the fresh memory about what the witnesses went on to testify about. And for me, things ended when I wrote to PRASA to say this is what is expected of Mr. Baltek. I was not given any further instructions from PRASA since, and I have not seen any document or report that related to the section 417 and 418 ever since that time up until what I see, what you're taking me through today.
Yes. Thank you. Can I conclude on this score before we adjourn? I had deliberately taken you to the second page of Mr. Baltek's report,
Yes.
which deals with the variation in relation to the GSMR contract. Tomorrow we will go to the first page of his report, and if you have time, please read it overnight and we can discuss it tomorrow.
Which report? The one on page 257?
257 indeed. You're welcome to take that file with you home if you want to.
Okay. Would there be any more documents that I'm expected to look at? Because I think it's a bit frustrating for me to see things for the first time, and I'm expected to speak on them.
If it were according to me, I would ask you to read the transcript on volume 16 of 1. And I see that my learned friend for the complainant is smiling derisively as if there's something wrong with the suggestion I make.
Sorry, Chair, there was nothing derisive. It's a long transcript. That was all.
It is distracting to say the least.
Yes, let me just interject here. What would you like the witness to be familiar with tomorrow?
The transcript of the 417 inquiry at volume 16 of 1.
Yes.
It begins at page 257.
Yeah. That's it. Anything
256, I'm sorry.
Anything else? That, volume 8, I think you've taken him to.
Indeed.
And any other volume, just so we don't waste time tomorrow.
The rest of the documentation
Will depend upon the evidence.
and Mizungu has taken him to them, so I'd like simply to confirm parts of it.
Yes. Thank you. Is there anything else, Mr.?
No, I mean the transcript of his testimony before the Zondo Commission, he knows it. I'm going to explore it with him, but he knows it.
No? Well, let's hope so. Yeah. Anything else?
Not from my side, Chair.
Yes, anything else, Mzungu?
Nothing else, Chairperson?
Well, yes. Then we will take today's adjournment. We will reconvene tomorrow, which is Wednesday.
Indeed, Chair.
And we will continue with the witnesses' further cross-examination.
Thank you, Chair.
Yes. We will then adjourn, be back tomorrow at 10 o'clock.
Thank you, Chair.